Hey, everybody, welcome back to the Law of Self-Defense show, the second show for today, Monday, December 19th, continuing to follow the trial of Aaron Dean. Okay, turn off those notifications. Aaron Dean, the former Fort Worth police officer who in 2018 shot and killed Atatiana Jefferson in her home while he was investigating an apparent burglary at the residence. We've been covering his trial for the last couple of weeks as it's been ongoing. Yesterday, or Friday, I suppose I should say, Dean was found, was it Friday or Thursday? In any case, Dean was found guilty of reckless manslaughter in this case. A patently wrongful conviction on the facts and law, so a real travesty of justice. In fact, Aaron Dean did nothing wrong, but he's been convicted wrongfully of reckless manslaughter in this case, and now he's being sentenced in an odd circumstance. He's being sentenced by the jury. Normally, the jury determines innocence or guilt, and then a judge handles sentencing. But Texas has a provision that allows the defendant to choose to have the jury sentence him too. So after the guilt phase of the trial, we have the sentencing phase, and it's like a mini trial in and of itself. The jury gets sentencing instructions like they would get jury instructions in the guilt phase. The state gets to present basically an opening or a closing, a statement to the jury about what they'd like to see in terms of a verdict. Then the defense gets to present its argument to the jury. Then the state gets a rebuttal. We heard all three of those this morning. The possible penalty here is anywhere from a minimum of probation, 2-year sentence, immediately probation. So that could be no prison time, all the way up to 20 years of prison time. So that's what the jury is debating now. Of course, the state's asking for 20 years and the defense is asking for probation, as one might expect. There's not a lot new to say about this trial. For those of you who may be new to it, again, Aaron Dean was a Fort Worth police officer, 1 year on the job, accompanied by a backup officer, Darch, a female officer, who were 3 weeks on the job when they were sent to investigate an open structure call at 2:30 a.m. Open structure calls are treated as silent alarms, possible burglaries in progress. The standard operating procedure for the Fort Worth police is to not announce their presence on scene until they've investigated and determined whether it appears there was a forcible entry or otherwise determined what seems to be going on. Within about a minute and a quarter of being on scene, Aaron Dean was shining his flashlight in through a window of the home, and he saw a gun being pointed at him. He gave brief verbal commands, then fired a shot that struck Atatiana Jefferson in the heart, immediately causing a mortal injury from which, of course, she did not recover. Within 2 days, Dean had been charged with murder in this case. This was all more than 3 years ago, October 2019, and then the past couple of weeks, we've had his trial. One of the lesser included crimes under murder is reckless manslaughter under Texas law. Of course, to the murder charge, Dean raised a legal defense of self-defense. He was defending himself against the gun. A gun was, in fact, found beside Atatiana Jefferson's body. The nephew she was babysitting, 8 years old, would tell an interviewer 2 hours after the shooting that he saw his aunt point the gun at the window. But ultimately, the jury did not convict on murder, but did convict on reckless manslaughter in this case, which is a nonsensical conviction on the facts and law. Reckless manslaughter is a killing that would occur under circumstances where the killer is knowingly creating an unjustified risk of death to others, but not intentionally causing the death. If it's an intentional death, it's a murder, unless, of course, it could be justified as self-defense. There was never any evidence of recklessness in Dean's use of force here. He intentionally shot her. There's no question about that. So it should have been, if anything, a murder conviction if you didn't buy the self-defense narrative. But obviously, the jury bought the self-defense narrative because they did not convict on murder. They convicted on reckless manslaughter when there's no evidence of recklessness. In fact, the opposite. Dean saying, I shot her. I did it on purpose. So apparently a kind of compromise verdict, independent of the law and evidence. The prosecution's legal arguments to the jury were, well, simply misstatements of the law. They misrepresented to the jury what the law of self-defense was under Texas law. They highlighted to the jury a bunch of less than optimal decisions by Dean that had nothing to do with his use of force decision, like how he crossed the street to the home. But of course, we do have a bad outcome here, right? Atatiana Jefferson certainly was not a bad actor. She was not a burglar. She was in her home, minding her own business, playing video games at 2:30 at night, babysitting for her nephew, probably heard the noise or the flashlight of Dean outside the home at 2:30 a.m., retrieved her own pistol for purposes of self-protection, and that's when the two people encountered each other, and it became, like that, a gunfight, which Dean happened to win. So it's an awful circumstance, a tragedy that Atatiana Jefferson was killed. And when we have a bad outcome case like we do here, the killing, I believe, here was legally justified. That doesn't mean it's a good outcome. It's a bad outcome. It's a lawful but awful event. But when you have a bad outcome case, there's often an emotional cry for something to be done. And something should be done probably in a civil sense. Of course, there is a civil suit taking place parallel with this criminal prosecution. But in terms of whether there's criminal liability, well, that's what we have criminal law for. There are specific crimes with specific elements, which the state has to prove beyond a reasonable doubt based on the actual evidence. There are specific legal defenses with specific elements that can be raised, in this case, self-defense, which the state has to disprove beyond a reasonable doubt based on the evidence. And the verdict the jury arrived here cannot be supported by the evidence in this case. So that's where we are. We have a wrongfully convicted police officer now waiting to hear if he's going to spend the rest, the next couple of decades, up to the next couple of decades in prison. So, yes, I understand. Obviously, I'm aware the jury found him guilty. Juries can wrongfully convict people all the time. This is not a guilty verdict that can be supported rationally by the law and evidence. So he was wrongfully convicted. He was convicted. He was wrongfully convicted. And I see the usual cop-hating children in the comments are losing their minds. But that's the way it is, folks. There's no rational explanation for a reckless manslaughter charge here. There was the use of force was intentional, not reckless. So if they believe it was unjustified, it would be murder. It can't reasonably be reckless manslaughter. It's impossible. Unfortunately, his Dean's legal team was awful. They were just terrible. They didn't well prepare they put their client on the stand. I think they needed to do that. But he was wholly inadequately prepared for his cross-examination. So that did not go well for him. Not on the substance, but on the theater. Because the state focused on all kinds of inconsequential conduct on his part, suggesting that couldn't he have done this better, or couldn't he have done that better? Couldn't he have crossed the street better? What if there had been snipers in the adjacent buildings? Did he slice the pie perfectly when he approached the home? None of which had anything to do with the use of force decision. So, my wife got her Christmas present early. Oh, there we go. And she's very happy. All right. Sorry. She just texted me that. None of which had anything to do with the actual use of force decision. No one pointed to anything reckless in his use of force decision. A gun was being pointed at him in dark circumstances. The only other eyewitness there was the 8-year-old who provided testimony that he saw his aunt point the gun at the officer. Can't be more clear-cut than that. So the state's case was all deflection to inconsequential matters and misstatements of the law, misrepresentations of what's required for self-defense. And the defense team let him get away with it. The defense team, first of all, should have known that that would be the state's case, because the state's case does not have merit on law and evidence. So the other side, if they don't have the law to pound the law, and they don't have the evidence to pound the evidence, they're going to pound the table. That's all that's left. And the defense was completely unprepared to deal with these deflections and misrepresentations of the law by the state. So this defendant, Aaron Dean, got screwed by his lawyers. Sorry, there's no other nice way to say it. A better prepared, more capable legal team would almost certainly not have had this wrongful conviction. And now we're waiting on the sentence. So what do we got? A few hundred people in. Let's see how many likes. Not good enough, folks. One of these days, I am actually going to shut down the YouTube stream. If you're watching on YouTube, there's over 600 of you, only 120 likes. So if you'd like the YouTube stream to continue, doesn't cost you a penny, but you got to hit that like button, folks. We need at least 50% likes. So if you could hit that like thumbs up on YouTube, that would be greatly appreciated. If we could... Let me make sure that the Rumble is working. It appears that it is. Law of Self-Defense dashboard is working. And Twitter is working. Although Twitter doesn't have a very good interface for this kind of thing, but it doesn't cost extra to put it up there, so I do that as well. And if you want questions or comments addressed directly by me or any of the guests who may pop in, and I have sent out guest invites to everybody, that's fine. If you're a law self-defense member, just put it in the chat, but please preface it with question, the word question in all capitals, so I can differentiate the questions from just the chatter going on in the background. Otherwise, it's easy for me to miss a question in the member chat. And if you're on YouTube, it needs to be a super chat. $5, folks. YouTube super chat if you want to be certain that I'll answer your question, or if you want to show appreciation for the content. I will say, if you're paying $5 super chats, I think it would be more cost effective for you to simply become a law self-defense member, because then I'll answer all your questions for no additional charge, and it's less than $10 a month to be a member, folks. $9.95, I think it is, about 30 cents a day to be a member, and you get as many questions answered as you want in the member chat, instead of having to pay $5 a day per question on YouTube, a third of which, by the way, YouTube takes. And you can become a law self-defense member right now, instantly, and join the stream and the chat on the member dashboard by going to lawofselfdefense.com/join. That's lawofselfdefense.com/join. So while we're waiting on the jury in sentencing, my fallback is I'll replay key portions of the trial. I'll replay the opening statement from the prosecution, from the defense, and key testimony, the defendant's own testimony, particularly the cross-examination, perhaps the closing statements again, kind of play that in the background. Who knows how many hours it's going to take for the jury to come back. And I'll also entertain guests as they may pop in, and I will answer questions, especially the super chats and the law self-defense member questions, and maybe some others. Dispel a lot of the lies and misrepresentations, misunderstandings that the comments tend to fill up with, especially from the cop-hating children who just have this emotional, visceral response to these kinds of questions. And we'll see where we go from there. It's going to be a matter of some patience, I'm afraid. So let's see. So law self-defense member Will Parker. Will Parker, folks. I think I have a little banner here for Will. Will Parker is a self-defense instructor up in Montana. Does great work. Graduate of the Law of Self-Defense. There it is. Instructor program. Very, very committed self-defense instructor up in the Kalispell area of Montana, Glacier National Park, beautiful part of the country. But he teaches students. Students go there from all the states surrounding it, as far as California. Will's hosted me to teach my law self-defense courses up there several times. Always been a great experience. Will asks, why didn't the presiding judge correct the prosecutor's misstatement of law? Well, if you ask the judge, he'd say he did. He'd say, well, I instructed the jury at the end of testimony when both parties closed. I gave the jury the correct law of self-defense in the jury instructions. The problem is that by the end of the trial, the jury's actually already made the decision. Hey, here's a guest. Hey.
Hey, Andrew, how you doing?
Good. A little dark where you are.
Yeah,
maybe
well,
backlighting.
Yeah, my office a little bit. But no, you were just mentioning about the judge reading the instructions.
Yep.
Well, if you're not opposing him, it's not his. If you've agreed to him.
Well, no, the instructions were fine. The instructions were accurate, but it was the prosecution's stating of the law throughout their closing arguments that was wrong. And of course, that's what's convincing the jury. The jury's not being convinced by the jury instructions. They're being convinced by the arguments they hear in court. So they hear the state presenting a version of self-defense that they're going to presume that version, especially if the defense is not objecting, they're going to presume it's being, no one's objecting. The judge isn't saying anything. The other side's not saying anything. This must be the way it is. And they'll arrive at their conclusions based on that representation. And then it's impossible to move them from that in deliberations.
Well, that's what I was getting at. If you don't object and you're not telling anybody it's wrong, then nobody's going to fix it. The judge is not going to jump in absent some really seriously egregious way of you would really have to screw up to have the judge jump in.
And unfortunately, the misstatements of law by the state are probably non-appealable because of the lack of objection.
I watched it. Yeah, I covered the female prosecutor when she went.
Yep.
I mean, gosh, I saw Steve with all the little things he put together in the meantime, but yeah, that one was really bad. There were so many misstatements. It was very prejudicial. I started to watch the rebuttal argument. It was just as bad. But yeah, if you don't object, you are saying, I'm okay with this.
And the defense never presented the correct law of self-defense. So they just let these misstatements by the state. Not only didn't they object, you might argue maybe they didn't object because they think the judge doesn't like objections and would give them a hard time if they objected every time the state made a improper argument. I would say, well, who cares? You're supposed to zealously advocate for your client. But even if you believe that the defense made a strategic decision not to object at every opportunity, when they get their turn to talk, they can clear it up. They can talk about that's not what self-defense is. You'll see in the instructions. Self-defense requires this, not that. Self-defense, it doesn't matter whether the victim's perceptions were reasonable. That's not what's relevant to self-defense. What has to be reasonable is our client's perceptions. It's not necessary that he have been facing an actual unlawful use of force. No one's arguing that Atatiana's retrieval of her gun to defend herself against a presumed prowler, was unlawful, but that doesn't matter. What matters is whether he had a reason to believe the force he was defending himself against was unlawful. They never did any of that. So if the jury believes, hey, Danny.
Hey,
welcome.
For having me on.
Hey, Danny.
So if the jury believes that if Tatiana was reasonable, there goes self-defense, or if the jury believes that the threat against the officer had to be unlawful, there goes self-defense, well, there would go self-defense. The weird thing is, of course, if the jury was convinced that self-defense was off the table, the conviction here should have been murder, because then it's just an intentional killing. The officer never said, I killed her by accident. He never said, I didn't mean to shoot her. He said, I intentionally shot her. That's a murder unless you can justify it as self-defense. So, but they didn't. The jury didn't convict on murder. The jury convicted on reckless manslaughter, which makes literally no sense because the defendant himself is saying it's an intentional shooting. Recklessness is an unintended act. So it's just a logically and legally incoherent verdict here by the jury, which suggests it had to simply been a compromise verdict, emotionally driven, not based on law and evidence. And that's a wrongful conviction. It's not on the legal merits.
If he is sentenced to probation only, do you think that he will appeal?
No way. You'd have to be crazy.
So
even
if it's wrong, even if the decision is wrong, we're still going to come to the same outcome, which is, if he gets probation as a result, then he's not appealing it. So even though it's wrongful, somehow we're all okay with this, right?
If he gets any minimal sentence, even if it's a couple years in, it's you'd have to be crazy because at least murder is off the table, right? So say he appeals and he wins his appeal. The appellate court doesn't find him not guilty. The appellate court just says, no, there were legal errors made at the trial. We're going to throw that trial out. We're going to remand for a new trial. Well, at the new trial, who says the outcome will be better? At the new trial, he might get convicted of murder, and he'd be looking at 99 years.
And the other thing is everything he said already, that's baked into the cake. Like he's, his there's issues about retrials with when you say prior testimony. So everything that's the other witnesses have said is already done. They're not going to be able to go back and undo that. So,
yeah, I mean, I just don't think anything he said.
No advantage to doing it again.
Yeah, I mean, I think if he found himself in a position where he was being retried, I think he'd have a great chance at an acquittal if he had a competent legal team. Because this trial could have been run far, far better. He ought not have been convicted on the facts in this case, the law of this case. And I think the reason we're dealing with sentencing now is because his defense team just effed up. They just did a bad job.
Mm-hmm. Well,
so if he had a better legal team the second time around, I think he'd have a good prospect for an acquittal. The trouble is, like most criminal defendants, they're completely uninformed consumers of legal services. So I'm sure he thought he had a great legal team this time. He doesn't know. He can't tell.
Not
so how would he make a more informed decision?
Always go and vet your attorneys before selecting an attorney. Look at the other cases that they've taken on. Look at what work they've done in the past. And to the extent that you can watch video of them performing, definitely go back and review that video and see if that's the trial attorney that you want to work with.
But I think that would matter to people like us who know what we're seeing. I'm not sure that matters to a layperson. They can't tell. It's like if I was watching I don't know, a rugby game. I don't know anything about how rugby is supposed to be played, or what's that stupid baseball imitation game, the cricket. If I'm watching a cricket game, I have no idea what's going on. I can't tell if someone's making good plays or not good plays, right? I think for most people, that's what it's like watching lawyers operate in court. They don't know what's supposed to be happening.
Well, and the weird thing for Dean here is he's a cop, so certainly he would have gone around and asked other cops or had names given to him by other police officers. Somebody tells me this wasn't just randomly out of a hat. So this is really weird that this may have been like the PBA even said, like, here are the guys we recommend. And this was the best they came up with.
Yeah.
So I'd argue he's in a better position than most people.
Maybe. I don't know. I mean, just because you can get recommendations from other people doesn't mean they're making informed recommendations either.
I agree, but it's his situation, though. I think the amount of people around him and the people, his profession interacts with attorneys a lot. I'd say he's a little bit better off typically than just the random person out there. Like right now, anybody watching this,
maybe
it's still not as good as us.
It didn't work.
Yeah. No, I agree. That's why I'm surprised.
So, yeah, very, very unfortunate. We have the usual ignorant comments in the chat. No, he wasn't trespassing, folks. Trespassing is when you're on property without license. Police officers responding to a call under exigent circumstance have license to come onto the property, at least to the extent he did. He never entered the home, for example. He went through an open gate to be able to inspect the outside of the home for signs of forced entry, which is what he's supposed to do under his SOP. So he wasn't trespassing. If he wasn't responding to a call, if he's just walking down the street and goes into someone's backyard, not for purposes of performing his duty, sure, that would be trespass, but that's not what we have here. And folks, you don't have an absolute expectation of privacy. You have a reasonable expectation of privacy. The Constitution doesn't protect you absolutely from searches. It protects you from unreasonable searches. So some of you need to read the Constitution. Actually, go look at the words and read it. Maybe you'll develop something of an actual informed understanding instead of this imaginary understanding of what you think your rights are under the Constitution.
Actually, what do you think about coming on my channel? Not that I'm proposing this outright, and you're free to say no, and I won't be offended, but I thought it would be really interesting to have a clause-by-clause breakdown of the Constitution with other attorneys who specialize in various areas. So, in your case where you're focused on the second and the fifth and the fourth and, how they all play together and coordinate. Whereas, my focus is much more on the first and the second, and to, kind of get other attorneys sort of practical experience with these constitutional amendments and to educate people on what the Constitution actually says versus the way that it's been interpreted over time.
I think it's a great idea. I'm not sure I'm the best person for that, to tell you the truth. I don't really do gun law, so I don't claim any particular expertise in the Second Amendment other than being a Second Amendment absolutist. In terms of believing that every gun law. See, I'm probably not the right guest.
Wait, so are you saying that I get my own gunship? Because if so,
sure.
I think oh my gosh.
Sure.
Andrew.
Letter of marque. It's in the Constitution, provided for in the Constitution.
Oh.
I didn't think I could like you and respect you anymore, but.
Yeah, I think all gun laws preemptively applied to law-abiding, mentally sound American citizens are facially unconstitutional. At least up to the point of crew-served weapons. There, I can begin to have a discussion about whether or not that would be restricted under the Constitution. I think not, though. People had cannons, so
I should be able to go home in my garage and sit there and stare at my battery of cruise missiles on a trailer if I want to, I think.
So, yeah, that would be... I wouldn't mind having a cannon. That would be pretty cool.
I worked for a defense company, and I won't say which one, but speaking of missiles on trailers, we were going out to the test range, and I was riding with one of the engineers, and I kept hearing the sound of cans, like aluminum cans bouncing around in the background. And I told him, I said, why don't we pull over and tighten down these cans? Because I would actually really like a Diet Coke or something once we get there, because the testing grounds are always like super hot and in the middle of nowhere and just miserable, right? And they should be. But we get there, and well, before we get there, he pulls over the truck, and we go out to the back. It's just unsecured load. It's just fire. It's giant booms in the back of our truck that are just bouncing around, and I'm going, oh my gosh. And these are all live ordnance, and it was a lot of fun though. It was a lot of fun. I wouldn't mind having one. That's my point.
It's always fun turning money into noise. Let's see. Question from a law self-defense member, Kansaki. He asks, Andrew, since he's been convicted, what sentence would you give him and why? I'd give him the absolute minimum sentence because I think it's a wrongful conviction. If it could be nothing, I'd give him nothing. Because this is a legally incoherent conviction, not supported by the law or the evidence, any view of the law or evidence. Because there's never been any evidence that his use of force was reckless. Maybe the way he crossed the street was reckless. Maybe the way he sliced the pie on a door unrelated to the shooting, you're not happy with. But none of that involves the actual use of force. It's like, a classic reckless manslaughter would be drunk driving. You get drunk, you get behind the wheel of your car. You're not intending to run anybody over, but because you're drunk on the way home, you run somebody over and kill them. It's reckless. It's creating an unjustified risk of death to another human being. When you get behind the wheel and drive drunk, that would be a reckless homicide. But the recklessness is you getting drunk. That's proximate to the operation of the vehicle. It's not that you when you got up that morning and put your shoes on, you didn't bother lacing your shoes. It's not that you had an unhealthy breakfast. It's not that you did other unrelated things that maybe could have been done better. It's not even you didn't put your seatbelt on. Is it reckless not to put your seatbelt on? I don't know, maybe. But that's got nothing to do with you actually striking and killing another person with your vehicle. The drinking did that. But they can't convict you of reckless homicide with a vehicle because you didn't tie your shoes that morning. Whatever the claimed recklessness is has to be proximate to what caused the death. Here, if he had handled his gun recklessly, maybe if he'd had it out of the holster already, or if it had a hammer and he'd cocked it. I mean, there are facts you can imagine that might have constituted recklessness in the course of the actual use of force, but none of those facts actually exist here. So there's no way to get to reckless manslaughter here. I'm a facts and law.
Do you have a super chat to read, or?
Oh, go ahead. Listen, we could be here all day. At least I could be here all day. You
all
folks,
right.
of course,
So I just wanted to
go.
interject. Have you guys talked about the Amber Heard settlement?
We haven't. I just saw the headline come across my computer.
So $1 million from the insurance company, and I'm not that mad about it. Except I wonder who's going to pay for the attorney's fees.
I don't know.
And I wonder.
It's a smart play by her, though. I mean, this is a win for her, totally. For sure. I mean, it doesn't take anything away from Johnny. I don't think he cared about the money. So he cared about the verdict, and he got that. He doesn't need $10 million from Amber Heard. He doesn't need the million. Let's face it. The million is just a way of saying, well, look, it wasn't bullshit. It was a real verdict. It was worth $1 million. That's what I'm getting. But for Amber Heard, it's a win. The problem goes away. She doesn't have to try to, spend the rest of her life paying off this judgment. And apparently she's still allowed to ambiguously refer to her truth, to kind of publicly suggest that it wasn't defamation.
I would have wrapped that up in the verdict or in the settlement, because the way that I see it is he had nothing to gain really from any of this except for the exposure that he had during trial and making this public and showing himself and what happened and showing the truth. Why would you then allow her to go on spewing the nonsense and the lies and this fake narrative? If it were me in that settlement agreement, I'd say, hey, look, I'll let you write off this debt. Essentially, that's what she did. We'll write it off, but in exchange, you're not going to talk any more crap. This ends here. This ends right now. And I just see this going down this pathway of future litigation. I don't see it ending here, but she already filed an appeal. Is that right?
Who filed an appeal?
Amber Heard.
Against the judgment?
I think so.
The original judgment.
So this is a settlement to the...
That must make the appeal go away, right? I mean...
Right. That's what I would assume. And so I don't know, if I were the attorney, if I were Depp's attorney, I would absolutely make sure that was in the settlement agreement. Is, look, you can say whatever you want, but this false narrative of him abusing you and whatever else, that needs to stop right now.
It looks like she's being deliberately ambiguous, right? I'm looking at a little clip of her statement from TMZ being recounted on TMZ, and it reads, it's important for me to say that I never chose this. I defended my truth, and in doing so, my life as I knew it was destroyed. Well, she's not saying, I still am saying that he abused me, but of course, how else would you interpret defended my truth? So who knows? All I can say is, like, during the trial itself, my feeling was, listen, if I was in that jury, I would find against both of them for $500 million for wasting my time. These people with their private islands and jets and $3,000 a day wine habits. And for God's sakes, you can't find any better way to spend your time than this nonsense?
I don't know. I don't think it should matter how wealthy or how poor you are. If you're the victim of domestic violence, which in this case, Johnny clearly was, I think that you have the right to speak the truth and to stand up for yourself and say, well, wait a second, I tolerated your BS during the relationship. That shouldn't extend beyond that relationship or be an excuse for you to further defame me and destroy my life.
No, fair enough. Right. Once she made the false accusation, he had to respond. I mean, she destroyed his career otherwise. Right.
And I have a tremendous amount of sympathy. I don't have sympathy, though, for stupidity. And I just feel like this settlement doesn't cross the T's or dot the I's in the way that you would expect or hope.
Yeah, there's a way for these, these settlements to be accompanied by a joint statement by both parties, drafted by their lawyers, where we're basically saying, hey, we're just not going to talk about it anymore. Everyone's happy. We're just going our own way, and that's all we have to say about it.
Yeah,
without getting either party, remounting the defensive ramparts of their truth, whatever that means.
And I just see that coming down the pike so fast, because she's already saying things like, the justice system failed me here in America, not like it did in Britain and da da da. And it's like, well, wait.
Where she wasn't even a party.
Exactly. And so she's sitting here besmirching now our justice system, saying that she was wronged in some way. It's like she's just setting herself up for another defamation case. If it's not against if it's not Johnny asserting a defamation claim, there's definitely going to be others, and she clearly didn't learn her lesson, and that's
she'll never learn her lesson.
Yeah, no, I don't think she'll ever go away. I mean, I think this is all she has, right? So she doesn't have the looks anymore. She doesn't have the acting anymore. I doubt. Can't see how anybody would hire her for
she could go become an attorney.
I doubt it. Her JD stepped on a bee. But maybe if she can just be one of these, I don't know, personalities in the TMZ sphere that just kind of rotates through National Enquirer covers and that kind of thing. And I don't know how you make a living doing that, but there must be some pool of money they attract.
$10 she says she ends up on The View as a guest host. Host on The View. She would be perfect for it.
As a survivor and advocate.
Right.
Yeah.
Right.
To talk about women's issues
Yep.
and domestic violence.
Yep. If she can sober up. I mean, there's a lot of, I remember seeing clips of her many public appearances when she was married to Johnny and after being married to Johnny before the big suit here in the U.S. And she often appeared intoxicated to me in public. Like every time
So
she
does all
made
of
a
The
guest
View.
appearance.
Oh, she could get a job on MSNBC or CNN then,
Right.
right?
But she could go get her law degree, be a CNN legal analyst. Sunny Hostin pulled it off for a while.
Hey, if it works, it works.
If she can do it, anybody can do it. I did a debate with Sunny Hostin at UC Berkeley Law School on Stand Your Ground quite a few years ago, and
Wow.
her, of course, I defended Stand Your Ground on legal grounds, and her rebuttal was to read a Sotomayor dissent from an affirmative action case. Just it literally had nothing to do with Stand Your Ground at all.
Justice Sotomayor. I can't, after what happened with the vaccine mandate that came down and her responses in that oral argument, I just, my level of respect is not high. I have serious concerns about our Supreme Court justices after listening to those arguments.
Yeah, she's just not very bright.
No, not at all. No, not at all.
So much for the wise Latina argument. All right, let me see here. What sentence would I give him? From Law Self-Defense member Kyle, question and comment. Is it even feasible to fight for law or precedent where an innocent party doesn't pay the price of corrupt DAs and feckless defenders? I mean, it should be 100 guilty go free rather than one innocent going to prison. Well, we had kind of a perfect storm here. I mean, we had prosecutors willing to try to put someone in prison for 99 years based on nothing, and just rhetoric and screaming and emotion and misstatements of law and evidence, just making up evidence, testifying themselves, just creating evidence out of thin air. So we had those DAs. That, unfortunately, in my experience, is not that uncommon. A lot of these high-profile cases I cover, the DAs are like that, just like Rittenhouse, Binger in the Rittenhouse case, just like the prosecution in the George Zimmerman trial. They all do much the same thing. Unfortunately, for this defendant, Aaron Dean, he didn't have a Zimmerman legal defense or a Rittenhouse legal defense. He had this legal defense, and that wasn't enough. It should have been enough. I mean, this should not have been a difficult prosecution to defeat. It was pretty obvious what their game plan was going to be because it was all they had were screaming and rhetoric and misstatements of law and evidence, because on the law and evidence, there's no way to a conviction here. And the defense should have been prepared for that. And it appears to me that they weren't. Now, in fairness, the lead counsel on this trial died just a couple weeks ago.
Wait, what?
Yeah, so Dean's actual lawyer from the beginning was an older attorney who just got old and got sick and died just a couple weeks before the trial. And his two lawyers, defense counsel in the trial itself that we saw, they weren't brought in at the death. They had been brought on over the summer because I guess the lead counsel knew there was a chance he was going to die. He was in very poor health. So they'd been on the case for some months, but not for 3 years. Still, some months should have been enough in this case. So I'm not sure that's an excuse, but I feel obliged to point it out.
That's kind of a big deal, though. I'm glad that you brought that up because I thought that they appeared unprepared, especially on that close. And it makes a lot more sense now why they lacked a narrative, why they, fundamentally couldn't build that narrative throughout their court case, and where there were missing pieces, because whoever the lead attorney is really has the most clarity on where the case is going to go, how they want to orchestrate and produce the case. And I say produce because it is a lot like entertainment and putting on a show and production.
Yeah. Yep.
And so when you have a narrative, you have all the parts, you have your experts, you know what questions you're going to ask. And then that person is the one to pass away. And everybody has to now scramble to put this all together. I could see why things were as difficult as it was for the defense.
I'd be more inclined to feel that way if the defense counsel had been brought on board just 2 weeks ago when the lawyer died, but they were brought on sometime during the summer. So they've had some months to consider the case. They had the opportunity to converse with the lead counsel over that period of time. So, yeah, for sure. I mean, if the lead lawyer just dies and the new counsel is appointed in that moment, yeah, you got to delay the trial. I mean, you got to give new counsel an opportunity to get up to speed on things. But I think they had that opportunity, which is why the trial wasn't delayed. All right, let's see. Yeah, so is it feasible to rely on law or precedent when you have these corrupt DAs and feckless defenders? Well, unfortunately, the key answer is have better prosecutors. Prosecutors have unbelievable power, authority, and discretion, and that tends to work okay if you have good prosecutors. But you give that power, authority, and discretion to politically motivated prosecutors, and you get politically motivated trials. That's how that works. Mm-hmm. In terms of defense counsel,
local elections matter.
Yep, they sure do. And in terms of, because prosecutors have always had these extraordinary powers, and we never really noticed because most of the time they handled it appropriately. But now we have a whole generation now of these George Soros funded, politically motivated prosecutors. And they always say only give as much power to someone else as you would want your worst enemy to have. Right. Well, some of these people are arguably society's worst enemies, and they're using those powers accordingly. In terms of quality of defense counsel, I mean, I don't know what to tell you. If I were involved in a use of force case, I'd talk to me. But obviously that's a self-serving statement, but at least I know that I know what I'm talking about. For most people, most lay people are not well positioned to be able to assess the quality of their prospective defense attorney. All the lawyers look like lawyers. They sound like lawyers. They walk and talk like lawyers. Until you see them in action. And even then, when you see them in action, you still have to know what you're looking for. It's really, really tough for the typical person to know whether they're retaining someone of quality. I think it's different in kind of commercial law, civil law, where everything moves at kind of a slower pace and you can get referrals from other people in business. Have you worked with this lawyer? Were the outcomes good? Do you feel you got good representation? That kind of stuff. But that would be like in the normal course of business. Most normal people are never involved in the criminal justice system. And if they get fed into it, it's once in their life. And so they don't have those avenues for evaluating whether their criminal defense attorney is any good or not. This is the only time they've ever met that person. They'll probably, hopefully, never have to deal with them again. So it's all decisions being made in the moment. And you kind of, it's like when you go to a doctor, do you really know how good that doctor is? I mean, most people don't. They just assume the guy's a doctor. He must be fine.
Yeah, I mean, to some extent, it also applies in the commercial area, and especially in family law. That's where I think we have a niche, is we can come out here and sort of, people say that I sound dumb, and it's not that I sound dumb. It's that I'm trying to simplify very complex legal arguments and complex legal issues so that everyone can understand, because I think that we have a populace. I know we have a populace that does not understand the rules. They do not understand the law. And
even worse, they think they do.
Exactly. We have this court and we have this system that's designed to make sure that people have access to the rules, to make sure that the law does apply to them, regardless of whether or not they fully understand it. But that it's designed to be accessible. And there's been this movement as of late to try and speak clearly and more simply, and to remove legalese from legal writing. But the problem that we have when it comes to family law and to people choosing attorneys for their commercial or for just general, contract disputes, is that every attorney now charges a consultation fee when you come in. So there's already a sunk cost fallacy when you leave the office. It's like, oh, well, I spent $200 to, talk to this attorney for 15 minutes. And he sounded like he knew what he was doing, or she knew what she was doing. So I guess I should probably just, and that $200 can go to my retainer. So I might as well just hire them and have that $200 not go to
Which is why they collected $200.
Exactly. And so to be fair to the layperson, there's not a lot of avenues to vet attorneys generally, to your point.
Yeah, I mean, one of the services we provide to our platinum members at Law of Self-Defense is if they're involved in a use of force event, of course, they get my legal services for free as a platinum member. But as a consequence of that, I'm also obviously talking to their attorney. And so I'm in effect vetting their attorney. If their attorney sounds like they're really over their head and don't know what they're talking about, well, that platinum member is going to hear that from me. And okay, let's see. Another question. Joseph, can you discuss how this case is a good example of why you shouldn't point your gun at unknown people in your backyard? That's how these accidents happen. You know, I have to be honest. First of all, that's a tactical question, not a legal question per se. And I don't have a lot of problems with what Atatiana Jefferson did here. She probably reasonably suspected there was a prowler outside her house with a flashlight. She had no reason to believe it was the police. There wasn't anything going on where you would expect the police to show up per se. She retrieved her gun to be prepared to defend herself and her child. We can't pretend it. You know, normal human beings, lawfully entitled to have a gun to protect themselves and their family, they're not going to be tactical experts. So
I'm not going to lie. I might have been in that exact same spot as her.
Yeah.
Like I would have been almost ready to fire at that point.
And when that cop's flashlight hits that window, I don't know if any of you have ever had these flashlights on your face. You can't see anything. These are really bright. These are not your grandfather's, 2D cell batteries.
Lots of lumens.
Lots of lumens. It's like a white wall in front of you. You can't really see anything. It's scary. In fact, arguably, the flashlights themselves are a kind of defensive weapon because they're effectively blinding whoever you're putting it on, and they can't see what you're doing to defend yourself. So I would consider a flashlight in the eyes, if it were being done to me, to be an act of aggression. So I don't have a lot of problems with what she did. I mean, listen, it's a terrible outcome. Nobody thinks it's a good thing that Atatiana Jefferson died. Everybody wishes she was still alive. But, there are risks in life. And we live in a society where, thank God, we're allowed to own guns, and the police are armed and we're armed. And sometimes these things happen. Police shoot police all the time by mistake. It's just one of the negative externalities of having guns, which are vastly outweighed by the positive externalities. But no one says that bad things don't happen with guns. We just think the good things are vastly outweigh the negative things. Let's see. Kansaki, law self-defense member Kansaki. By the way, all these questions being answered for law self-defense members, folks. It doesn't cost them anything. Doesn't cost them anything. They're just members. It costs them just $9.95 a month to be a law self-defense member, and they get all their questions answered free instead of having to pay $5 super chats. Instead of $5 a question, $10 a month, and get all your questions answered. You become a member right now at lawselfdefense.com/join. But member Kansaki asks, do you put in reviews on these lawyers' profiles after watching their in-court product? No, I don't. I mean,
no.
I don't.
That would be. And if you're thinking about doing that, that's not. I wouldn't recommend that at all.
It's unprofessional. We're professionals.
And if you were going to do that out there as a person watching this, that's like Amber Heard type behavior. Don't be like that.
And first of all, I should point out, I'm seeing these attorneys in one case, right? Maybe it's a bad day. Maybe it's a bad week. Maybe they're under the weather. Maybe most of the, no one's 100% all the time. Anybody can have a bad day or a bad case.
Well, and there's a huge difference in terms of what quality of attorney you're getting or style of attorney you're getting, depending on where you are in the country and what's available to you. These gentlemen might be the best there is in that area. And so it'd be really silly for us to go and put them down for this one performance.
Yeah, and the particular facts of the case can make a big difference too, right? So this, if this dean had shot a burglar, an actual burglar, but maybe under circumstances where it could be made to look like excessive force or something along those lines, but it was a bad actor who got shot, the kind of technical, unemotional defense presented by these lawyers might have been much more effective than it was here. That maybe they just don't have the skills to overcome this narrative where the person who died was a 28-year-old, black woman shot by a white police officer. But the skills that need to be brought to the table are often very, very, whether or not they align well with the case depends on the specifics of the case often. Let's see. Everybody in the comment wants a cannon. That's good. Law self-defense member Chris, to the panel, should have Dean's defense team driven home the point that he wasn't charged for bad police work, and bad police work isn't a crime. Yeah, I would have definitely done that.
Yes. Yeah, that would
especially
not
when
have
the
been a bad
state keeps bringing it up, right? This whole crossing the street nonsense. None of that was proximate to the death of Atatiana Jefferson. And none of that's a crime. By the way, he wasn't charged with trespassing either. So all this notion that he was unlawfully in the backyard, that's ridiculous on its face. I mean, they could have charged him with that. And by the way, they didn't charge his partner officer with anything. She wasn't written up for any violation of procedure, and she was there with him every step of the way. Every place he went, she went too.
Yeah. Why wasn't she charged as an accomplice for murder?
I mean, they should have asked her, were you written up after this event for violating policy? For walking across the street wrong? For not pieing the door correctly? Is there anything in your records that chastising you for any of that? I mean, it's just crazy that the defense didn't do this, because you could see it. You could see it all coming. Let's see. Joseph here makes a comment disagreeing with me, with Andrew, says Tatiana never would have been allowed to shoot someone standing in her backyard with the flashlight. Therefore, she wouldn't be allowed to point her gun at the person.
Oh, so, I disagree.
Folks, yeah, I always caution. I discourage people from pointing guns under circumstances where they would not be privileged to shoot. I think it's better if you're only pointing your gun under circumstances where you would be privileged to actually shoot the gun. Now, once you point it, circumstances might change. It might not be necessary to shoot. Often just the appearance of the gun solves the problem. But I'm not a fan of defensive display of firearms for the purpose of deterring someone's behavior if you don't think it would be lawful to shoot. That said, in a lot of jurisdictions, they do draw a distinction between the mere threat of force and the actual use of force. And a lot of times prosecutors will let a mere display go and not treat it the same as if you'd fired a gun. In fact, a lot of prosecutors' offices will have an informal kind of algorithm where they'll say, all right, if the gun stays in the holster, but you make the person aware that you have it to defend yourself, that's one thing. If the gun comes out of the holster, that's another thing. Maybe we'll call that brandishing if we think it wasn't justified. If you put the muzzle on the person, then maybe we'll call that aggravated assault if we think it wasn't justified. And they have these little increments where they make their charging decisions based on slight variations in the facts, but none of that is law. That's all internal office policy within the prosecutor's office. And they can make an abruptly different policy decision in a politically energized case or a racially energized case if they want to. But it's not at all uncommon to see the mere display or pointing of a gun to be treated very differently than the actual use of the weapon.
Well, in addition to that, I think the guy's comment, though, has she shot, I don't ever recommend it, but I could easily, in this series of facts, make a justifiable argument why she was justified in using force at that threat that was outside her window.
Imagine she saw a silhouette outside the window, like the cop saw a silhouette inside the window, and there's two people outside the window, and the female officer had her gun out already. So she looks out her window, sees two silhouettes, one of them's got a gun in their hand. That's arguably an imminent deadly force threat to her in the house.
Yeah. Now, I do agree, though, yes, you should generally try to avoid engaging people outside your home if you're safe in your home. That should generally be an idea, but that's not the ultimate end-all be-all, because, you could be in danger from outside your house. Those people can shoot into your house. They can try to come through that window. I mean, there's a million different things that factor there. And I could easily argue, Atatiana, if she had smoked Dean and she was on trial for it, I'd have no problem defending her.
Yeah, no, there's a good self-defense narrative there. Defense of self and defense of others. Yeah, especially since the other she's defending would have been an 8-year-old who obviously can't defend himself, right, if she's overcome. Kyle Cowden, a law self-defense member, says Texas has an explicit law that if force is justified, the display of deadly force is also justified, if only to place the aggressor in fear or apprehension. These are what are called defensive display laws, folks, and they're really just feel-good laws. They don't change anything legally because they presume that the display was lawful. Well, was it lawful? I mean, if you're facing legal jeopardy, it's because somebody, a prosecutor, thinks it wasn't lawful, what you were doing. And if he thinks it wasn't lawful, the defensive display doesn't help you. Just like if you discharged a gun or actually shot somebody, all of those things are lawful if they're lawful. but it's a circular argument. You're begging the question beforehand. So I think they're nice to have on the books, these defensive display statutes, because they send a message to prosecutors, to jurors about what society kind of expects as being permissible, but they don't really change anything substantively. All right, let me see if we have any super chats. You know, a question. I'd love to have a Texas attorney on here because certainly Texas sentencing is not anything I have any expertise in, and this sentencing by jury is relatively unusual. There's only a few states that have any provision for this, and Texas obviously being one of them. But we all know what happens if the jury deadlocks on the guilt phase, right? It's a mistrial. Can have another trial. What happens if the sentencing jury, if this jury deadlocks in the sentencing phase, they can't agree on a sentence? Is that a mistrial of the whole trial, or does the finding of guilt still stand? What's the point of a finding of guilt if there's no sentence? Is it an incomplete, unperfected verdict?
It's weird. It's just weird.
Yes, it is.
Because look how long they're taking. I mean, this
I'm
started
surprised.
at what time? It's 1 o'clock. It's 3 o'clock, and I think it was about noon when they went in. So for 3 hours they've been talking. Of course, they had lunch, so maybe they've only been talking for 2 hours. But
yeah, it's 3 o'clock Central now. Yeah.
2 o'clock Central, right? Oh no, but I'm working off Eastern time, so I think it was noon Eastern time when they went into deliberation. So yeah.
Just a heads up, I do have to leave here in about 30 minutes, so I am going to grift while I can.
No, of course,
go and check out my website, or go and check out my YouTube channel, Danny on Direct. I actually just had an interview with the DUI guy. It was fascinating. I've interviewed Steve Gosney. We did a stream together, Bronca and I, that was really interesting about the Sig Sauer. And I hope to have other interviews on my channel because I think that there's a lot of people who want to learn about the practice of law, where they're considering law school and they have in their mind, this career path. And as we discussed on our show, the DUI guy and I, it never turns out quite the way you expected. Yeah. And so it's really important to know that just because you're doing family law right now, or just because you go into criminal defense, does not mean that you are now pigeonholed into one practice or another. And it's always interesting to get insights from other attorneys on career moves, advancement, how to sort of change your trajectory. So go and check out my and tonight I'm doing a live stream at 8:30. I will be discussing the Twitter files addendum, and TikTok was just banned here in Utah. So very interesting discussion.
And they can find you at
Danny on Direct. Oh,
just like in the little name there. All right. And Sean's muted.
Yeah, guys. Sure. No, thanks. You can find me at Potentially Criminal. I'm on YouTube, Locals, Rumble, everywhere under that. Try to talk about criminal defense topics that are going on. Today I'll be talking about, trying to put it out tonight, the attorneys out of New York City that got caught throwing Molotov cocktails. They got off pretty light considering what they did, especially given the fact that other people, using a fire extinguisher on police officers in the Capitol building, or, carrying a spear inside the Capitol building, are doing far, far more time than, chucking actual bombs at police officers. So it's a little interesting how that broke down. But
yeah, unfortunately, that's the world we live in, right?
Yeah.
If the people who control the laws are members of the same tribe as the accused, they get a very different justice than if it's members of the other tribe. Tribal justice, exactly what our legal system is not supposed to foment. And I should mention, I just noticed today I hit 46,000 subscribers on YouTube. 46, can't believe it, because I'm really bad at this stuff. All right, let's see, a couple super chats. Phil Moore, $5 super chat. Thank you very much. Is it mandatory that the state pushes for max sentencing all the time, or do these prosecutors have no chill? These prosecutors have no chill. Yeah, it's not mandatory. Often the prosecutors will come up with some kind of medium-term sentence that they'll recommend. But of course, usually they're making recommendations to a judge, not to a jury. And a lot of states have very rigorous. I mean, this Texas thing is very loosey-goosey, it feels like. I pick anything between 2 and 20, right? If it had been a murder conviction, they would have said, pick anything between 5 and 99 years. It's entirely at the jury's discretion. A lot of states, and this federal government in particular, have very complicated sentencing algorithms with specific factors that are mitigating, factors that are aggravating, how much time they add, how many extra years for prior offenses and things like that. So it becomes kind of a computer program almost that ends up with the final sentence. There's a lot more constraints. A lot of states have mandatory minimum sentencing that really just take all discretion away, like Florida's 10-20 life law. So this Texas sentencing scheme feels unbelievably loosey-goosey to me, but I guess that's how they do it. Let's see. Wolfie, 17, $5 super chat says, does Law Self-Defense have a gift card or some way to buy a membership for a family member for Christmas or birthday? Also, Danny is looking beautiful today. There you go, Danny.
Thank you.
We've never thought of gift cards, but would certainly be happy to facilitate you buying any of our products and services for family members or friends. I would just encourage you to email support@lawofselfdefense.com, and they can make any arrangements that you like, especially for a platinum membership for a friend or family. That would be awesome. That would be a wonderful gift you could give to somebody. Let's see. Nancy Jennings, super chat, $5, says, if she shot first and killed the officer, how would this play out in your opinions? I think she'd have a very strong justification defense, a very strong self-defense, defense of self and defense of others claim.
Oh, very, very, very so. Very much so.
Yep, I'd shoot.
Hey, Kurt.
Hello.
Kurt!
How are you doing, man?
Hi, Kurt.
Good.
Good. All right. Glad to hear it.
Oh, Kurt, you got the question for Kurt. He might know. So if the jury doesn't come up with a sentence, what happens?
I don't actually know.
Now that you're a Texas lawyer.
Yeah. Come on,
I'm
man.
responsible for all Texas questions.
You go through all this work.
I don't know the answer to the question. I'm sorry.
Yeah, that's funny. I wonder if a quick Google search would tell me. What if a Texas jury deadlocks on sentencing?
Yeah.
Come on, Google.
Now I have to decide which other states to apply for. Got Pokemon catch 'em all style. Want to be the very best.
I was just listening to a Supreme Court hearing and I thought of you.
Thank you. Yeah.
And I'm actually curious if you've reviewed it. It's the one on gerrymandering that just came up, something v.
Oh yeah,
Moore.
yeah. I did that case.
Oh, okay. I'll have to go and watch your review because I'm really curious what your thoughts were on that.
My conclusion, I think, is that that North Carolina, what they did is probably proper, and I think they're probably just going to affirm. Probably
so,
on something like a 7-2 or 8-1 vote is my best guess.
Well, it doesn't look like I'm going to have an easy.
But if you want the
result
long
on
version,
Google.
there's like a 4-hour oral react.
That's what I'm going to go watch. That's what I meant.
See, there you go.
Yeah, I don't know what happens. It's an interesting question. I wish we had an experienced Texas criminal defense attorney on board. But so we all know what happens if the jury deadlocks on the guilt phase. It's a mistrial. But if they return a guilty verdict, like here, however irrational and wrongfully, return a guilty verdict on reckless manslaughter, but then they can't agree on a sentence. Is that an unperfected determination of guilt, or is there just no sentence, or?
I think they just throw them back in the washer and say, figure it out, and just send them more food and lock them away until
everyone gets to go to Dairy Queen.
they take a sentence from each juror, just average it out.
Yeah.
Oh, someone's posting here. Dan Readers, $5 super chat. Texas 3707, Section 3C. A mistrial is declared for the penalty phase only, and a new jury is impaneled. Oh, that makes sense. So they'd do their presentation of evidence again. They would do a retrial just for the sentencing phase. So they do that little presentation of evidence thing they did. They do new closing arguments, closing by the state, closing by the defense, rebuttal by the state, and then send that jury into deliberations.
There's got to be some.
That's weird, though,
provision.
right?
Because
that jury.
What if they just mistrial forever? What if they can never get a jury to agree?
Right.
But even if you impanel a new jury for the sentencing phase, they didn't watch the trial.
They should just play rock, paper, scissors. That's how you decide this, right?
Get one of those Dungeons and Dragons dice.
Yes.
Yeah.
Right?
Oh.
A 20-sided dice, right? It's
Yes.
if you roll a 1 or 2, it's 2 years. If you roll a 1, it's probation. 2 is 2 years, and then every number up there all the way up to 20.
There
I
you
mean,
go.
it's not out of the realm of possibility. We had Rittenhouse use what is that thing called?
Like the drum machine that they
Yeah,
had, or-
he used a
yeah.
drum machine to pull
Tumbler.
out his alternates.
Which is like an octagon for some reason, which I thought was kind of cool because it's not round like most of those are. With it's like got like 8 sides or 6 sides or something. It's like, okay.
It was so bizarre and hilarious because you could just hear the squeaky squeak.
It's like, can we get some gun
deciding
oil
this
here?
way.
It's like, hey, what have some gun oil so I can treat this thing?
Oh, it's funny.
Gun oil. Yeah. So, yeah, you almost wonder what's going on in the jurors' heads. You know, if some of them were like, didn't really think he was guilty, thought they were doing a compromise verdict, and that they could make it up on the penalty phase, and now they can't agree on the penalty phase, right? The people who wanted murder also want 20 years on the manslaughter. You know, the interesting question is, if he gets 20 years in the manslaughter, do you appeal that? Say you could
Why
appeal
wouldn't
it. Say, well, because if you appeal and win, you get a retrial. You could be found guilty of the murder.
Nah, I'd definitely chance it.
I would too.
Or can you?
I don't know.
Is it effectively an acquittal on the murder, so double jeopardy protects you from the murder?
I don't think it is
The
the
second
second
time.
acquittal. I think you could go for that upper count. Yeah.
There was a Supreme Court case about a tribal member that was somewhere along those lines. It was a capital case, and he was tried in state court or in federal court, and then tried in state, and then tried in under tribal law, and it was a mess. But even then, the Supreme Court held that wasn't a violation of due jeopardy or double jeopardy. Excuse me.
Yeah, I think there'd be a pretty good argument for double jeopardy on the murder, because reckless manslaughter was the lesser included. So before you get to reckless manslaughter, in theory, you had to first acquit on murder before you go to the lesser included.
I don't know. Texas is wonky, so.
Texas is wonky. Indeed. Let's see.
We need other things to talk about. I was covering the Johnny Depp Amber Heard settlement earlier today on my channel. I am disappointed that there is a settlement. I feel somewhat mildly betrayed on a personal level. I've been let down as a man.
I mean, I feel like the $1 million is enough to make a statement that clearly Depp was in the right and Amber Heard was in the wrong, except that apparently she's still allowed to talk about things like speaking her own truth, you know, ambiguously.
And the money's not coming from her. It's coming from the insurance company.
Yeah, well.
So what's it to her? So there's no pain. And the fact that there is a settlement that includes this $1 million payout from the insurance company is at least somewhat suggestive. There might be some sort of settlement with respect to the lawsuits between her and the insurance companies. Because otherwise, why would the insurance company agree to this $1 million?
No, it had to be a 3-way deal for sure.
I understand that.
Yeah.
So that's my point. So the fact that the insurance company signed off on agreeing to pay this $1 million to Depp is suggestive that there might be a settlement in the lawsuits between the insurance companies and Heard, because they've been battling about who's going to pay those bills and stuff. And it's like, well, this $1 million payout is suggestive that maybe those issues have also been resolved. So I'm not sure Amber Heard's necessarily on the hook for anything, depending on how all that pans out. You know?
Well,
So
I
I'm
mean,
not
for
sure
the
she's
insurance
not-
companies, it may not be a bad deal, right? They were potentially on the hook for a lot more, right?
Yeah.
Covering the whole set. So for $1 million, they limit their risk. Amber's happy if Depp will agree not to go after the 10 million because she's not guaranteed the insurance companies will cover it. And Depp probably doesn't really care about the money, but gets
doesn't.
enough money to reaffirm that he was in the right in terms of, you know, his career and all the stuff that he does care about.
But there's no admissions and there's
That's
no
the weird
non-disparagement.
thing, right?
Yeah,
Even if
He
there were
still
no,
looks like a guy here.
So she's going to continue doing exactly what she's been doing. I'm surprised she hasn't already written her newest op-ed about, you know, my truth of the trial, and just raking him over the coals again.
But Johnny had his day in court. He won. Let her scream into the wind. I think he's just done.
I'm not sure it's that necessarily the wind. I think there's a lot of groups that will continue to support her in the mainstream media, and a lot of these groups that signed off on that open letter. She's going to be a feature speaker on the circuit.
Well,
she's going to be speaking at some luncheons.
Here's the thing, Kurt. Some letters from Ben
some
Chu
awards.
Yeah, but here's the thing. Some letters from Ben Chu saying, "Listen, this bitch lies. We proved she lied. Nobody believed her the first time around. I'd watch letting her come speak. I mean, sincerely govern yourself accordingly. Sincerely, Ben Chu. That'll take care of a lot of problems, I think."
Yeah, I to your point, Kurt, though, these people, you have to understand, when we're working with people without virtue and people who genuinely do not care about principle, they will continue to lie and lie and lie and lie over and over again, even if the truth is sitting right there in front of their face and our faces, because they know that if they say it enough, if they repeat it enough, eventually they will change the narrative, they will frame it, and then anything you say against it will not matter.
Right. It doesn't have to be true.
I'm disagreeing with you at all.
Yeah.
I mean, I could have said everything you just said exactly. I agree with that completely. That's the problem.
And you'd think with $10 million in leverage, in terms of that judgment, they would have gotten a letter of agreement from her saying, I will never reference this matter again in any way, yes, however ambiguously.
Just saying, hey, we're not going to talk about this anymore. That's what's bizarre to me, is he had so much leverage to go and do that, and he decided not to. I think that was a huge mistake. I
mean, this is very common in civil settlements where you try to talk to the parties afterwards and they're like, look, I just can't talk about it.
Yeah.
Yeah.
But her voice has not been silenced, because that's the most valuable thing. And I'm like, well, what that means to me is I'm going to go out. I mean, Johnny Depp has to know that she's going to go out and continue telling the story in more aggravated form, I would say. I mean, it's like in a future lawsuit, you got res judicata problems because these issues have already potentially been adjudicated no matter what she says in the future. So you got legal problems out the ass for any kind of future suit. Plus, why would he? He's been showing himself to not be willing to stand up now. Why would he stand up later?
He's made the fool's errand of trusting and securing himself in the truth.
Yeah.
Yep. Hey, a couple questions here about this Aaron Dean trial. Law Self-Defense member Kyle asks, would it be okay, in other words, no negative blowback, to write the DA and complain about the behavior of their charges? I mean, there's nothing wrong with it, but he's not going to care unless you're in one of his potential voters. Why would he care what you think?
Yeah. But yeah, you have a right to petition, and freedom of speech. So feel free to write a non-threatening letter expressing your disappointment. That'll be fine.
Yeah. You can say whatever you want legally, but unless you're scratching out checks to him, he's not going to listen.
Yeah, I mean, there's a reason the prosecutor's office is doing it this way, right? They think it's advantageous for them to try this case in this manner. Let's see. Super chat, $5. Thank you very much. Tim Pools, Yamaka Beanie says, hey guys and Danny, what backwards shenanigans is this? Texas? Yes, of course it's Texas. I can't even pronounce that name, but a $5 super chat. According to the movie Basketball, if there's a hung jury on sentencing, a 2-man sack race will be held on consecutive Sundays until the clear winner emerges. Makes as much sense as anything else so far. It's yeah, it's terrible. It was terrible. It's always, I mean, I'm not. This guy, Aaron Dean's not a friend of mine. He's not a family member. It doesn't mean anything personally to me if he goes to prison or not. But I care a lot about the process, the legal process, because without a good process, you can't have any confidence in the verdict at the end. And this process was horrifically bad. The state just basically fabricated evidence. The prosecutor testified about facets of this case. Then he then used his own testimony in closing in a circular manner to urge the jury to convict. Like this officer was gung-ho. This officer was a hard charger. The only person who ever said those words in the actual course of the trial was the prosecutor himself. No witness ever suggested any of that. The blanket misstatements of the law Like the reasonableness that matters here is whether Atatiana Jefferson was being reasonable. That's not what matters in self-defense, folks. What matters in self-defense is whether the user of force is acting in a reasonable manner, has reasonable perceptions. It doesn't matter whether or not the other party is being reasonable or not. For this to be a lawful use of defensive force by the officer, Atatiana Jefferson's use of force or threat of force had to be unlawful. That's not what's required. His perception of it has to be that it's an unlawful use of force, but it doesn't actually have to be an unlawful use of force. And the prosecution knows all this. These are experienced prosecutors, but worse, it doesn't surprise me that the prosecutor would misrepresent the law like that. It's disappointing, but it's not that I haven't seen that kind of thing before. We all saw it in the Binger prosecution of Rittenhouse, them doing this kind of nonsense. But the defense team apparently doesn't know what self-defense law is in Texas when it's a straightforward self-defense case. I mean, why wouldn't you know every permutation, facet of self-defense law under Texas law? So the moment you hear the law being misstated, you could object. And maybe the judge overrules your objection, but at least you preserved it for appeal then. Very, very disappointing. In fact, worse, not only did the defense not object, but they bought in to the prosecution's misrepresentation of the law. So when the prosecution argued that, well, it's only self-defense if Tatiana was acting unlawfully, instead of objecting that that's not, in fact, the law, the defense said, well, she was acting unlawfully. You point a gun at a police officer, that's always unlawful. So they bought into the misrepresentation of the law, and they did it in a way that compelled the jury to now decide who they favored. The cop who fired the fatal shot into the 28-year-old or the dead 28-year-old. If one of them had to be wrong, and of course, emotionally, the jury's going to be inclined to favor the victim. In truth, neither one of them had to be wrong. Both of them could have been right. If they both fired simultaneously, they may both have been legally justified in firing those shots under mistake of fact, but they had a reasonable, if mistaken, perception of what they were defending themselves against.
As Ben Shapiro would say, two things can be true at the same time.
There you go.
Except he'd have a higher pitched voice when he said it.
Oh my gosh,
And fast,
I love
and
Ben
they speak
Shapiro.
faster.
You cannot insult Ben Shapiro to me. I have the
Did
biggest.
you know my
girl
wife's a
crush on him.
doctor?
I know his wife is a doctor. I am very well aware, and he's happily married with multiple children.
I believe he has a new one coming on the way too.
Oh, congratulations! Why can't I speak today? Man, I need some blood sugar. I need to go eat something. I swear.
And he's got a heck of a booster seat.
He's pretty tall. Well, I was sitting down when I met him in person, so.
I've got nothing against Ben Shapiro. My wife is also a super fan. So I have to listen to his voice in the house all the time until I can find her headphones for her.
It is grinding, but he's brilliant. And in the way that he's able to come up with stuff on the fly, the way he's able to quote cases, I have immense respect for that. Now, the fact that he's a globalist and some other things, his political leanings, he and I may disagree quite a bit.
So here's a question from Law Self-Defense member Mixter. Will Aaron Dean be personally liable in a civil suit, or will he have qualified immunity? So the way qualified immunity works, folks, is it's for the officer. It's not for his department. And it generally holds that if the officer's conducting himself within the course of his duties in a reasonable way, he's personally immunized against civil suit. You can still go after his department, which is what happens, of course. So the person who was injured still has a claim. And in fact, the claim still goes after the party with the deep pockets. I mean, the officer doesn't have any money. We don't pay police officers enough to pay off a multi-million-dollar judgment. Now, the exception to qualified immunity is if the officer's not acting reasonably within the course of his duties, he could not qualify for qualified immunity. Qualified immunity is not intended to protect bad actors in a law enforcement role. The trouble here for Aaron Dean, of course, is that he's been found guilty of reckless manslaughter, which would suggest that he was acting outside the normal course of his duties. So he may not qualify for qualified immunity. I think it hardly matters because they're suing for $10 million, I think. He doesn't have and never will have $10 million, especially as a convicted felon. But that, in theory, is how it works. Now, I do understand qualified immunity is a hot topic. I do understand lots of people believe, and often it does, in fact, protect officers who did engage in bad conduct, and they're not personally held accountable when they should have been. They were protected because a lot of times the judges making these qualified immunity calls, they don't know this law very well. They act like it just applies automatically to every police officer, no matter what they did. That's not how it's supposed to work. So when
No,
it's
it's not.
badly applied, you get bad outcomes, and people are understandably angry about those bad outcomes.
Yeah.
Also, qualified immunity, in the sense most people are thinking, is like in a 1983 claim. If the
Right.
family is suing at the state level, Texas may have its own version of qualified immunity at the state level, but qualified immunity won't be an issue at that point. It'll just be a state level claim, possibly. So it all depends on how they want to sue.
Right.
The real tricky part with the qualified immunity thing is the second prong of the analysis. You have to show that you had your constitutional rights violated, which is usually easy enough as far as it goes. But then you have to show that those rights are clearly established. And what the case law shows is that by clearly established, we require a case that is very factually close to the current case, more so than would be typically true in most situations. Lawyers reason by analogy. And so when you're filing any kind of case, really, you want to find cases that are comparables. So it's like, find cases that are similar. The problem with qualified immunity is that the comparables, as a practical matter, have to be much tighter and much more similar than in other kinds of cases. And the other part of the problem is that the appellate courts are not required to, and very rarely will establish it going forward. So they'll simply say, well, it's not clearly established, and stop the analysis.
Right.
They won't say, okay, no, this isn't the law, or yes, this is the law, which would be nice, right? So that we could actually build upon stuff. Qualified immunity probably wouldn't be so much a problem if the courts, at least the appellate courts, were required to say yes or no. Like, this is or is not a clearly established thing going forward. Then we would have case law building up, but that never happens.
Right.
Because it's like it's a catch-22. We don't have any case law, so we don't have to decide it. And now we don't have any case law because we don't have to decide it. And you basically never get new case law. It's a pain in the ass.
Yeah, it becomes a very iterative process where the first time you get away with it because it's never come up before, and the second time you get away with it, probably not the same cop, but you get away with it because the first time it wasn't held accountable. So there's no precedent for holding it accountable, and it just never happens. It's certainly a legal doctrine that could use some fine tuning for sure.
I don't know what the problem with the old doctrine was. I believe it was Skidmore, where it was just the basically the reasonable officer test. It's like, what would the reasonable, normal, prudent officer of ordinary, normal, prudence? It's the reasonable man test. It's the reasonable man test. The reasonable man test is great. It does everything you need it to do. And instead of that, we came up with this whole qualified immunity doctrine. And it doesn't matter how reasonable or not the officer was. Now it just matters because we move from this into this purely whether it's clearly established or not. And what's even perhaps more disturbing is it's not just police. It's all governmental officials. So you try suing a school or suing other governmental agencies, you're going to run into the exact same problem. So I have many thoughts on qualified immunity.
So we have a super chat here, $5 from Kingslayer Damocles. Says thank you very much. Says, all I have to say is don't be a Texas cop in a mistake of fact self-defense case in someone's home. Officers should have learned this from Amber Geiger. The problem is you're always operating with imperfect information. No one has perfect information. It's a mistake of fact case because you think you're doing it right. It's only identifiable as a mistake of fact case after the fact. So if that's the requirement, just don't do that. What you're going to do is have cops just not do their job unless they have perfect information. And the only way to have perfect information is to get the call, wait long enough for everyone to die, and then go there with a chalk line and just chalk line the bodies.
Yep.
Then you have perfect information. But it's not very good law enforcement.
Unfortunately, a lot of people now think that that's the role of law enforcement, or at least that it should be the role of law enforcement, which is a terrifying standard. And I think that's why you're seeing qualified immunity be threatened to the degree that it has been as of late, is because there's this movement to have police officers not really be enforcers of the law, but really enforcers of the law after the fact. They're not there to serve and protect. They're just there to serve and then show up after. That's a serious movement that I heard a lot on the campaign trail. A lot of people discussed these issues with me, and that's what they wanted to see in the future. It was very concerning.
Law self-defense member Chris B asks, could Dean have benefited from a law of self-defense platinum membership in this case? If he'd had it, he could have. First of all, he would have gotten my legal analysis on the self-defense aspects of the case for free as a platinum member. And also, let's see, I should have that here. But also certainly, if he'd wanted and his lawyers were interested, I would have advised on the entire case, including, hey, what's your opening going to look like? Are you prepared to respond to these attacks from the prosecution? How do you plan to address these likely arguments the state is going to make? Are you going to have the game show buzzer on your effing table? So when they sprout misstatement of law, evidence not in the record, that you bam, 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 that you're calling that stuff out, are you going to sit there like an idiot?
The buzzer's a good idea.
I like the buzzer idea. Can we make that a thing?
Wouldn't that be awesome? Like the big game show red, right? It's in fact, I did a little video with Steve Gosney. We played it earlier this morning. Let me see if I can find it, where we took the state's opening and I inserted a buzzer sound every time they made improper argument, and then put a little flash up on the screen what the imperfect argument was from Steve's book. Steve has a whole chapter in his book, Ideas and Answers in the Law, on improper argument by the state, on closing. And yeah, we had some fun with that. Let me see if I can pull that up.
When did you publish that? Today?
I put it together post-production yesterday. Yeah, we played it for the first time today.
I'm really excited to watch that. That'll be fun.
But I think I do have to modulate. Where the hell is it?
Oh, that's what my parents always
people
told me.
complained about the buzzer, that the buzzer was too loud.
Well, I love you guys to death. It's so fun. Thank you so much for having me on. I don't know where Sean just disappeared to. I love you too, Sean. Thank you. And I'll see you guys later.
Okay.
All right. Thanks for coming in, Danny.
Thank you for having me. Bye.
Bye-bye. You and me, bro.
Just you and me. Yeah, I'm going to see if I can find that.
Just the two of us. We can make it if we try. Just the two of us. You and I.
All right, so I did find it, but I'm gonna fix the audio first, folks. Let's see, because I know that was bothering people, and I had neglected to kind of normalize the sound first. So that'll take me just a minute, but I'll play it shortly. Take care of that. So what other topics are you covering on your, and tell people where to find you on civil law?
Yes, you can find me on my channel, Uncivil Law, where we cover a lot of appellate courts, a lot of U.S. Supreme Court cases, try to do some oral argument reacts, and other things that are happening in the news. We've got some interesting ones coming up on the channel in the near future. We got a story dealing with a public university where a female soccer player was she's suing because she says that she was benched for not kneeling. So her team wanted to do for Black Lives Matter. They wanted to kneel for Black Lives Matter. She didn't want to do it because she objected to it for personal reasons. And she went from playing something like, basically all the game, like 85 minutes or something in a game, to like playing 4. And so basically she's saying she was retaliated against for her viewpoint. So that is a story that's coming up on my channel. And let's see, what else do I have coming up? I've got a case dealing with another case from universities. This case from Indiana, where some students are suing because their university charged them fees for on-campus stuff, and then not so much with the on-campus stuff because there was no on-campus because of the proof.
Right.
And they kept all the money. And it's just like, you were charging us for the dorm fees and charging us for the meal plan and charging us for the student activity fees, and not so much. And so there is a case that I'm covering on my channel dealing with that, and also a case dealing with Google, who just gave perhaps one of the largest privacy settlements ever. 40 states attorneys general were suing Google because for a 5-year period, people were saying, I'd like to not share my location information. And Google was saying, I'd very much like you to share your location information, and I'm going to do that without telling you about it, even though you told me not to. And so they were suing for that, and Google just paid a $400 million settlement, which to Google is probably rounding error, but still. And so those are some of the stories that are upcoming on my channel.
Good day for the
civil law.
What piece of that did the lawyers get?
Who knows, right? Well, it's the state's
Somebody had a
attorneys
good
general,
day.
so probably not very
Oh,
much.
I
To be
see.
honest.
Yeah. Mm.
Yeah. So it's public action. So
Right. Well, there you go. Hey, they can fund more prosecutions like of this police officer. It's
if you're interested in such things, I just did a live stream earlier today where I went through the settlement for Amber Heard, Johnny Depp, so you can check that out. We'll go through that and try to talk about my disappointments and implications and stuff like that. So
did you go through her statement? I understand it was a very lengthy statement.
I did, where she expressed dismay at the entire entire justice system and how it has failed her and how she will not be silenced, which means I can look forward to more words coming out of her mouth in the future, which, is exciting and fun for all of us.
That is disappointing.
Yes.
Maybe Johnny was drunk when he signed that. Wouldn't shock anybody, I guess.
Thinking. I don't really know what he was thinking because I covered the briefs that were filed. I thought Johnny Depp had a pretty good argument on appeal for overturning the judgment against him. The Amber Heard won $2 million against Depp for statements that his attorney Waldman made. He's not an employee, so respondeat superior doesn't work. And there is no evidence on the record that shows direction that Johnny Depp was directing this. And also it's not logical to conclude it as a matter of principle because attorneys by their nature are independent. You hire an attorney to do a job and you don't really worry about the details. Which is kind of true for all professionals, to be honest. When you go to a mechanic, it's like, I want my wheel to not wobble so much. You don't really then say how I want you to go about accomplishing that objective, right? So it's kind of true for all professionals. So it wouldn't make sense that he's directing it like implied, and you have no statements that show it because all those statements are protected by privilege. And so you can't get to where you want to be. So I thought Johnny Depp's arguments to overturn the verdict as a matter of law were really, really good. On the other hand, Amber Heard's appeals sucked, as been covered by basically everyone who's reviewed it, particularly the amici briefs, which were harsh shows of just, we don't like the jury. And they're bad because this is sending the wrong message, because that's definitely something the appellate court thinks about. It's like the message that's being sent. Sure. So I don't really get it. If he's not interested in the money, I totally understand. I mean, he's a famous actor. He's well compensated, and she doesn't have any money anyway. So I mean, she might have some money, but not enough to make him whole in any sense. So what's $2 million to him, or 10? She doesn't have $10 million. So what's $2 million or whatever she has, assuming he can ever get it, to him? It's like, okay, it's not worth it. I understand. So you want to settle for $1? I get it. But why you don't also have a admission and non-disparagement as part of that? It's like, if you want to bring up your reputation, her saying, you were right, Johnny, would go a really long way. Now, she's not going to do that, which is why you don't settle, right? I mean, she's not going to agree to that. But then just fight the case, because unless I'm missing something in the legal equation, I don't really see what he really had to lose on the appeal. It seemed pretty good to me. So unless I'm missing something on the analysis, I don't get it.
Well, as usual, when I cover one of these cases and have opinions that other people don't like, they start coming at me, bro. I just got a Facebook request, a friend request on Facebook from my dad, except it's not my dad. They just took his photo and used it. Yeah. They just.
Well, what do you think?
Do
you disagree with my opinion
with the Depp thing?
Yeah.
It doesn't make any sense to me. To me, the only thing that should matter to Depp is not the money, but stopping this defamation of his character, being able to suggest, even imply, however ambiguously, that maybe it was all true. Maybe he was an abuser all along, and the legal system just went crazy. So I never would have allowed him to settle for anything. I would have. He would have been better off settling for $0 and a letter saying she'll never mention this again, than $1 million and she gets to keep talking about it.
Yeah, I agree.
Because the money to him ought to be inconsequential. I mean,
agree.
that perfume, that Sauvage, he probably gets $1 million a month from that endorsement.
Yeah. I forget how much it was. I read his. I used to know it at one point because it was in one of the documents that how much he made. He did well for himself with the Sauvage deal.
So the only thing of consequence should be her ability to keep talking about this stuff, and to let that go for any amount of money seems to be a bad deal.
Yeah. She's going to think it's a victory. You know, she doesn't have to pay anything out of pocket. So she doesn't have any feeling of accountability. She's going to feel like she's a narcissist. She's not going to reflect on this in any way. She is well illustrating that she's going to continue speaking. And I would not be surprised at all for there to be future op-eds, which are much more aggressive than what we've seen in the past. Because at this point, I don't know what her disincentives are to do that, to be honest.
Well, all her incentives, absent a letter prohibiting the conduct, is to talk about it, right? Because, like you say, if she's perceived as being a victim, abused not just by Depp but by the legal system itself, yeah, I mean, she'll be on The View, right? She'll be on some other talking head show. She'll get well paid for that, in terms of well paid for Amber Heard and then any skill set she has to bring to the table. She can't act, and she's too old to act now anyway. That was all her looks, and the looks aren't there anymore. What does she have to bring to the table? How's she going to support herself? I mean, what is she going to do exactly? Get a man? I mean, is there someone crazy enough to take on that hot mess?
Oh, there's a lot of men crazy enough to take on that hot mess. I know there's a lot of men of means who are able to take on that hot mess, but you never know. There's some weird people out there.
Fair enough. Let's see. Scalzo Photo, $10 super chat. Thank you very much. Says, according to Mr. Law Self-Defense, Aaron Dean is not guilty. I'm tired of the cop is incompetent, dumb, did no investigation or surveillance, so he can't be held responsible for his horrific acts. Well, there's a dumb person in this conversation, but it's not Aaron Dean, and it's not me. It's you. He was investigating. That's exactly what he was doing when this happened. So there you go. And he was investigating in a manner that was consistent with his department's policy. The state never presented a single police witness from the Fort Worth Police Department saying he did anything wrong in terms of his approach or conduct on the scene. Not one.
Yeah, I really. But
thanks for the $10
to tell me. I really would like this jury to tell me what they really think he should have done differently that would have mattered and doesn't lead to its own set of problems. Like I you know, where if he knocks on the door, you know, that leads to its own set of problems. You know, it alerts potential intruder because, like, you know, because again, you don't know what the situation is walking up to the house. How you can't possibly know what it is. You don't know if she's in there. You don't know if it's a burglar. You don't know what the situation is. So announcing your presence could lead to some counter problems. And so in some alternate universe where it really was like a burglary or maybe like a quasi hostage situation even, and the police announce themselves and the you know, the hostage taker shoots them, someone's going to sue, be like, oh, you shouldn't have announced yourself. What were you thinking? Right. So what I don't understand is what the jury thinks they should have done that wouldn't have also been a problem in some alternate scenario. And I don't know that they've thought this all the way through.
Yeah. And the defense should have done that with their police policy expert. It's another line of questioning they never pursued with their expert witness on police policy. Isn't it true all these things have trade-offs? Right? If you choose a different path, it has its own set of trade-offs. And the department is making the decision about what balance of risks and benefits it thinks is most appropriate, and it requires its officers to do. That's not up to the officer, is it? That's up to the department. But there is no perfect answer.
No, there's not.
But the defense never did that.
Yeah, and these details that they kept went into is like, oh, you spent only a second looking at the car. You spent only a second looking at the shed. It's like, well, you're trying to, because time is a factor here. Time, again, you don't know what the situation is going on inside. Time is potentially a factor. You don't know how long. The longer you are outside lurking about and making noise is more opportunity for the bad guy to potentially hear you or see your flashlight or, you know, glance out a window or whatever, or just do whatever they were doing inside the house and maybe alert themselves to the police presence and potentially take a position against them. So time is a factor. So like everything the cop did seemed like something that made total sense. It's like, I'm going to do some sort of quick sweep, you know, of the car to look into there. I'm going to do a quick sweep of the barn. I don't see any obvious signs of broken entry. I don't see any signs of anyone obvious in there. I'm doing a quick assessment, quick, or I'm just, a quick clear, popping in, from room to room to just see if anyone's there, quickly, and then I'll go look under the beds and in the closets as I have more time, for example. So those ideas make total logical sense to me. And I just don't really understand what the jury really thinks the solution was here. I mean, it's a bad outcome, and I totally understand that perspective of it.
They could have been misled into the reckless manslaughter. They could have been misled into thinking that if they don't like the way he crossed the street, then that's recklessness sufficient to support that the shooting was manslaughter. That's not the law, and it's the job of the defense to make clear that's not the law. That he would have had to do something.
You need a causality.
Right.
You need
something
a causality
proximate to the actual cause of death.
Yeah, something that proximate. Yeah, something that caused it. So it's like, is this parking across the street reckless?
Right.
Sure. How does that lead to the shooting? How does that mistake, assuming it is one, cause the thing? There's no causal connection. So it doesn't really matter one way or another, it seems to me.
I love the chat, man. Someone's complaining in all capital letters. He didn't even try CRP. It's CPR, folks. Let's see. Somebody's writing here. Lost self-defense member Kyle. He's talking about the Amber Geiger case. Says, I pulled the data and audio files on Amber Geiger. Verdict was correct. Amber Geiger was the Dallas police officer, lived in an apartment building, walked into the wrong apartment, and the apartment of Botham Jean, walked in the unlocked door, saw him, and believed she was in her own apartment and drew her pistol and shot him. He was sitting there watching TV, eating ice cream when he heard the door open behind him. Tragic shooting. I don't even remember what it was exactly she got convicted of. I presume manslaughter.
No, it was murder. It was murder. She got sentenced to 10 years, as memory serves.
Oh, right. So my recollection is correct that they convicted her of murder, but she got a manslaughter-like sentence from the judge.
Yes.
Yeah.
I mean, the jury is able to do that in 10 years.
Was that a jury sentence?
Yeah.
In that case?
Mm-hmm.
Okay.
Yeah.
I didn't know because I think in Texas it can go either way. The jury can sentence or the judge can sentence. It's at the request of the defendant.
Yeah. The jury is sentenced to 10 years in that case. And then you get out in half of that with good time. And so I'm not sure that she appealed because I'm not sure that she could have done any better.
Yeah, I mean, it's a difficult case. It's very fact sensitive. I mean, one of the things that bothered me about that case is apparently the defense had surveyed the people who live in the apartment, and something like a third of them had either themselves accidentally walked into the wrong apartment or had other people accidentally walk into their apartment. So this was common. It wasn't bizarre on the part of Amber Geiger. It's not like she was the only person this ever happened to in that apartment complex. And most of us have lived in apartment complexes that are like that. I mean, basically, they're all homogenous. They all look largely the same. Should she have known when she stepped through that door that she was in the wrong apartment? I mean, maybe.
Well, there was that big red floor mat, which was their big thing. It's like, how could you not see this big red floor mat? So,
yeah, I mean, it's hard to say. So I was a student in a tactical course one time, and we were doing a house clearing exercise. So with real guns. So shooting real bullets, cardboard targets, and you had to kind of work your way through this house, slice the pie, do all that tactical nonsense, and shoot the shoot targets, don't shoot the no shoot targets, and work your way all the way through to the far side of the house. And I did that. I thought I did a great job, and they failed me on the exercise because they had taken one cardboard target, all of which are just vertically kind of facing you, but they had taken one target, a shoot target, a bad guy target, and just laid it on the ground. And I never saw it. I just walked right over it. So it's not hard for me to imagine how something on the ground is something you wouldn't notice when you're looking for threats in front of you.
Fair.
But the difficulty I have is I feel kind of like those facts could go either way. Should she have known? Should she not have known? Is it excusable that she didn't know? But the guilt is supposed to be proven beyond a reasonable doubt. And I think given the circumstance of how many people walked into the wrong apartment by accident, that it would be difficult to prove that beyond a reasonable doubt to my satisfaction. I don't think she knew she was in his apartment or not in her own apartment. I think it was a mistake of fact case. But again, and I think she'd worked a super long shift the night before or something along those lines, which, also is a factor, of course, in how attentive you are to details. It's not like his door was locked. It was unlocked. Maybe that should have alerted her. I don't know. It didn't feel like an act of murder to me, is the point. I could understand how someone could make the mistake. Perhaps recklessness, perhaps. But again, where's the knowing creation of risk? Certainly negligence.
Yeah. By the way, I've never mentioned before that I do like your background with the simplistic, the law, self-defense. I think it looks good.
Thank you. Yeah, when I was still working from my home office, I had all the bric-a-brac in the back and the certificates and diplomas and all that kind of stuff. But when we got the office, we just painted the wall blue and put a decal up. It seems to work okay.
Yeah, easy peasy.
Constant promotion. That's good. Constant grift. Auto grift mode activated.
Yeah. I always just thought it was a green screen. The fact that it's actually painted wall is even cooler.
Yeah. We just had the wall painted blue, and that's actually I put that decal up myself. So we just ordered a decal, and you peel it off the plastic and you press it up against the wall, and at least on camera, you can't see the bubbles I left in it. So there you go.
Nice. Look at you, all professional.
JM, $10 super chat says, you know what you get when you put the police in a no-win situation? Detroit. The police become purely a cleanup crew, like discussed. I mean, how are you a Fort Worth police officer today responding to an apparent burglary in progress call? What do you do? Do they send 20 officers to every suspected burglary in progress so they can guard all the exits, so they can check every box of that standard operating procedure that would require 20 officers to do simultaneously? Mm-hmm. Can the Fort Worth Police Department afford those kinds of resources? I doubt it. I mean, they're already running a department with one officer per car. So clearly they don't have an abundance of officers. They're going to send 20 cars?
I don't think they're going to get an abundance now.
I would think it would be pretty tough. I was talking to someone who's involved in hiring at a very, very large police department, and he told me they recently put out a call for hires, and they got not one application. Not one application. That's got to be scary as shit. And all the cops who can get off the street are getting off the street. I know the guys I talk to, if they're close enough to retirement, they retire. If they're not quite close enough to retirement, they get academy jobs, public affairs jobs, headquarters jobs, anything that's not on the street where they might have to go hands-on with the suspect. End up using force and finding themselves prosecuted like this, which means is one of the reasons we end up with this increasing number of police use of force scenarios where the cop in question is a rookie. I mean, in this case, Aaron Dean was on the force for 1 year.
Yeah.
His partner, his backup partner, Officer Darch, the female officer, it was her third week as a police officer. Third week. In the George Floyd case, Derek Chauvin was a career cop. He'd been on for 20 years, but those other three cops with him were all rookies. One of them, it was his first call. And that guy got 2 life sentences.
I didn't really feel that for a lot of those. For Chauvin, I totally got it. But for the other three, I was like, I don't know how you're getting there. It's like, what are they supposed to do? It's impossible.
It feels more like not even like a politically motivated prosecution, but almost a religious kind of prosecution, right? There's a violation of dogma here, of a matter of faith, and they have to be burned at the stake. It's terrible. But we're only going to see more of that, folks, because all the senior cops are getting off the street if they can. And so who are they going to be replaced with? New recruits. 5 years on, 3 years on, 1 year on, 3 weeks on responding to a burglary in progress call. It's we're not going to get better outcomes. We're not going to get better use of force decisions. We're going to get more bad decisions, arguably bad decisions. By the way, which some people profit from. The Benjamin Crumps of the world make a lot of money off bad police use of force decisions, tens of millions of dollars a year. So it's good for them if you have a naive, unskilled, inexperienced police force making bad use of force decisions.
Well, I've been looking for a new grift. Maybe that's the way to go. Given all these rookie cops, I would have a booming business. Just move around from place to place.
And they're all settlements. They're all settlements.
Yeah.
And I guarantee you, plenty of attorneys are looking at Benjamin Crump saying, yeah, I'd like to have a yacht. That sounds pretty sweet. And I never actually have to go to trial. These departments will just settle because they're always happy to spend, Politicians are always happy to spend other people's money to make their political problems go away. So it's an easy grift. And lawyers are good at this. Lawyers see these opportunities for making money, and they're like, "Oh yeah, I can do that. I can specialize in that." That sounds fun. Let's see. Someone sent me what is this? A new buzzer sound. Okay.
Is it the screaming goat?
It's like an anime lawyer pointing his finger angrily and shouting objection.
Okay.
In fact, I'll pull it up.
Ace Attorney.
Up, right?
Objection.
It says Phoenix Wright Ace Attorney. Yeah, that's what it
There
is.
you go. Yeah.
Here, I'll pull
Those
it up.
games drive me crazy. They absolutely are insane. They demoralize me on a personal level.
All right, here it is.
Yeah.
Objection!
That's it.
Yep.
Question from Law Self-Defense member Mixter. Any ideas about the death of Dean's defense attorney just before the trial was a contributory factor in his incompetent defense? Might that constitute grounds for an appeal? No, I don't see how. And it's not like these lawyers were brought on at the last minute. The lawyer ended up dying at the last minute, but he knew he was dying apparently because these co-counsel were brought on this past summer. So they've been involved with the case for months. It's not like they were a sudden substitution. Will Parker asks, is it reasonable to compare the Dean arrival with limited information and acting with the Uvalde police arriving and awaiting further information prior to acting? Well, no, the difference is with Dean, he'd arrived with limited information and was actively attempting to acquire additional information. So to affirm what was going on, Uvalde just hung out and waited. So they were not acting. Dean was acting in accordance with procedures, what he's supposed to be doing, looking for signs of forcible entry into the dwelling. He was doing the opposite of Uvalde. Let's see. Someone sent me some Texas criminal procedure stuff. Yeah, folks, I had already pulled up that section, but it's hundreds and hundreds of words, and I can't find the one or two sentences you think might be appropriate while I'm doing the show live. So, section 3.3. Let me see. That might help. Let's see. 3705, section 3.3. All right. Well, now I'm looking at 3705, and there is no section 3.3. So that wasn't helpful. So if you have a correct reference, I'll be happy to look it up. Off-topic question from Alexi. What would it take to get your American law courses accredited somehow so as to give university credits? Would it be excessively annoying, expensive, so it wouldn't be worth it? Well, it wouldn't be worth it to me. So no, I'm not going to do that. Then I have to deal with some kind of accrediting agency. I'm not interested in that. I'm interested in recruiting very experienced lawyers in their fields to teach these topics because they have a passion for teaching and for people's personal interest. I don't want to deal with that. I'm not trying to become an actual university. Besides, then I'd probably be required to do stuff like equity instruction and all the toxic politics that I'm seeking actively to avoid by having people have an option to go someplace other than a law school to learn this stuff. So no, I'm not interested in any of that. Law self-defense member Kyle says, I've got a buddy in the Fort Worth Police Department. He said, unless there's gunplay involved, good luck getting any kind of response to an open structure call. Well, that's what you would expect to be the consequence of this prosecution, right? For the police. Law self-defense member Kansaki asks, do you think policing should return to civil policing with the official police just doing investigations after the fact? I don't know what you mean by civil policing. If you mean individual citizens acting as police, how'd that work out for the McMichaels in Georgia? making a citizen's arrest of Ahmaud Arbery.
Yeah.
And Roddy Bryan, who really did nothing but videotape things. So they all got life sentences, right? So no, I could not in good conscience encourage anyone to act in a civilian law enforcement capacity, like making a citizen's arrest. And in that case, by the way, the citizen's arrest was the key to everything, because if the citizen's arrest was lawful, then everything that followed was lawful. And if it was not lawful, then everything that followed was not lawful. So it was the key to everything. And the judge allowed an ambiguous citizen's arrest statute to go to the jury without clarification. So we don't know what interpretation the jury gave to that 150-year-old citizen's arrest statute with very ambiguous language. And that's not how it's supposed to work. The jury's not supposed to decide what the law is supposed to be. They're supposed to be given a clear explanation of the law and then apply that clear explanation of the law to the facts as they believe the facts to have been proven or disproven. But the jury's not supposed to be deciding what the law is. And the judge just left it ambiguous. He didn't do his job. Now, if he had done his job, because the citizen's arrest law was ambiguous, the interpretation he gave to the jury under the doctrine of lenity should have been the interpretation most favorable to the defense, which would have been almost certainly to lead to an acquittal. But he didn't want to do that. So he left it ambiguous. So yeah, I consider those to be unjust convictions too. Now, if you had the trial again with a clarified reading instruction on the citizen's arrest, might they be convicted again? Sure. And then I'd have no problem with that. But leaving the law, deciding the law, what the law actually means up to the jury is not the way the system's supposed to work. They're not legal professionals.
No.
Let's see. Law Self-Defense member Kansaki says, sorry, Kurt, you can't be a new Benjamin Crump because you ain't black. Well, you're certainly not black. That's true. I'm not sure how much of a barrier that would be. Law Self-Defense member Kansaki says, question, so it's damned if we do, damned if we don't versus criminals. Yeah, mostly. That's why I discourage you from engaging with a criminal in any way unless there's actual life at stake. And then maybe it's worth it risking, death in the fight and going to prison for the rest of your life. But I wouldn't do it because I saw someone maybe burglarizing the house under construction across the street. That didn't work out well. And was it worth it for those guys? Now, if you're about to be killed, then of course you defend yourself, right? Or someone you love, someone you have a duty to protect is about to be killed or maimed. You do what's necessary because maybe it's worth going to prison to prevent that from happening. But it's not a long list of things that are worth dying over or worth going to prison for 20 years or life over. So think about it now. Decide. I don't tell people what to do or not do. So I don't tell people when to go to the gun, when not to go to the gun, when to get into a fight, when not to get into a fight. You have to decide that for yourself. I just hope to help people make an informed decision about where they're drawing that line, so they're not surprised. I mean, I tell you, the cases I consult on, the most common thing I hear from clients is, I can't believe I'm getting prosecuted for self-defense. They're surprised. Don't be surprised. If you get yourself into a fight, maybe it was a worthy cause, but don't be surprised if you get prosecuted. It's not up to you anymore. Once you're engaged in that fight, your future is out of your hands. Whether you're getting charged, whether you're getting prosecuted, it's not up to you. It's up to other people whose interests may be contrary to your interest. They may actually be hostile to your interest. They may think you're actually a racist murderer, and they're going to treat you like one. And that's completely out of your hands now. So think what's worth that. Some things are, but not a lot of things. Let's see.
I prefer not to go to jail for the rest of my life. That's just, yeah. Or really at all, to be quite honest.
Let's see. Jill Sanderson, $5. If I'm a criminal defense attorney, can I call you from my client questions as well as my own exposure as a platinum member? I'm not sure I understand, but if you're a criminal defense attorney and you're a platinum member, if you're involved in the use of force events, you get my legal consultation for free as a platinum member, but not for your clients. Your clients would have to be a platinum member to get my legal consultation.
That was their question.
Prior to this year, prior to this year, we routinely took outside consults from people who were not platinum members. We just charged them a minimum of $10,000 for the consult. But this year, we're not taking outside consults anymore. So if you had called last year, we probably would have taken the consult. But 2022, moving forward, we're only doing consults for platinum members. So the good news is you don't have to pay 10 grand. The bad news is you have to be a platinum member, period. Then there's no cost to you, but that's the only way to get our legal consult. And you can learn more about that right on the screen here, Law of Self-Defense Platinum membership at lawofselfdefense.com/platinum. And by the way, this shouldn't even need saying, but you need to have been a platinum member at the time of the use of force event. You don't get to get into the fight and shoot somebody and then become a platinum member and get the legal consult. We actually had that happen earlier this year. Guy became a platinum member and then immediately called for a consult on a use of force event from 2 years prior that he was finally going to trial on. No, my friend, that's not how it works. So best to become a member today. You don't know when you're going to get attacked, right? That's not up to you. Normal law-abiding people, we don't get to choose the time, place, and manner of our attack. The bad guy does that. Could it never happen? Hopefully it never happens. Could it happen tomorrow? This afternoon? It's not up to you. It's up to them. Edmund D, $5 super chat says, are the societal implications of prosecutors imprisoning LEOs in their own communities considered or ignored to pursue professional political goals? Well, I think these prosecutors are pursuing their near-term political interests. They don't care about the broader policy implications. That's above their pay grade, doesn't impact them directly. They all live in safe neighborhoods. The cops will come when they call. So,
yep.
It's very, very, it's unfortunate, but these are the political drivers we've created in modern America. We did this to ourselves, really, by electing these prosecutors. Of course, most people have no idea who the prosecutor is, right? I mean, they get that ballot. They don't know those names. They don't know who this guy is. They don't know who his competition is. They probably vote by party. And traditionally, most of these prosecutors' races were not often contested. I mean, often the prosecutor was a long-standing member of the legal community who'd been there forever. Sometimes prosecutors are in that job for 20 years. They're just there forever. And mostly because they're not making any waves. It's very a low-key function that normal law-abiding people aren't paying any attention to. And so the races for these prosecutor seats were pretty low-key too. I mean, a few $1,000s might be spent in a race for a prosecutor's office. Everyone pretty knows the old guy's going to get elected again. So when someone like George Soros comes in and funds somebody with $100,000 to run for a local prosecutor, they're getting TV commercials and billboards going up. Just the name familiarity alone, that's a bought seat. That's a purchased seat right there. It's and you know, people figure it out. These seats are extremely powerful from a societal perspective, and they're easy to buy and cheap to buy. So here we are. Let's see. Law of Self-Defense member, third part intervener, asks, could the jury have asked for a clarification of the law in this case? Had some juror realized the prosecutor just misstated what they had in front of them? The trouble is that the jury doesn't get the instructions, which appear to be correct. So the formal instructions they were given by the judge appear to be fine, but they don't get those until they've heard the closing, until they've heard the argument throughout the trial, until they've heard all the misstatements of the law. And, you know, they're told not to arrive at a verdict until the end, but you know they're thinking about it the whole trial. They're incrementally coming to a decision over the course of the trial. And if that decision is all based on misstatements of law, and then they get these pages of legalese with the correct legal instructions, thinking that the correct legal instructions are going to solve the error from the misstatements of law is foolish. I mean, maybe you'd have some super nerdy intellectual juror who would do that, but most jurors have already made up their mind by the time they're in deliberations. Could they ask for clarification? If they ask the judge for clarification, he's going to refer them to the jury instructions that he already gave them.
Yep.
Law self-defense member Kansaki asked, do you provide consult on federal cases for self-defense if the defendant was platinum and whatnot? Yeah, sure. The federal doesn't make any difference to me. All 50 states, all U.S. territories, federal law The self.
Guam?
Of course, we customize. What's that?
Guam?
Guam. Yeah, I'll do Guam.
Hello?
I've looked at the Guam
There you go.
self-defense law. Yeah.
There you go.
But the truth is that there's federal self-defense cases are really very rare. They're 99.99% of self-defense cases are going to be state level cases. If it involved some kind of federal law enforcement, maybe, that would have jurisdiction. It would be difficult to get to. It's not easy to get to federal court on a self-defense case. It doesn't happen very often. And the cases you tend to see they tend to be deprivation of rights cases, like in the Ahmaud Arbery case or the George Floyd case. And then by then you've already lost at state. Typically, if you're going to federal court, they already have the state convictions in hand. So self-defense is generally off the table as a practical matter.
Yeah.
But if you're just a normal citizen going about your day and you're worried you might, shoot somebody in self-defense and end up in federal court, it's probably not likely. Let's see.
Yeah. Short of being on tribal
by the way,
land, or
what's that?
Like short of being on tribal land or in a national park or national forest, or yeah.
Well, I will concede. So that could be an issue. Is in parts of the country, especially out where I live these days, there's a lot of Indian reservations, and some states are huge blocks of them are Indian reservation, where you could fall under tribal law. And I have to confess, I don't know a damn thing about how Native Americans do their tribal law. So that could be an issue. I tend to avoid going on reservations, frankly, if I can, because it complicates things like having a gun on your person too. I've gotten up to some reservations and they have these giant billboards, no guns allowed. And all right, well, I'm turning around because I don't know what they use for. I'll be in a little teepee prison or something. One of these days I'll have to look into the tribal issue, but I've never had a consult come up there. So, all right.
It'll be an exciting future for you. Come out of Oklahoma, and then you can deal with that whole nightmare.
Yeah, it seems like almost the whole state's reservation land. And then they had that federal court ruling basically throwing out all the convictions that had been done in state court within the reservations.
Yeah, that led to one of my favorite videos. Is Oklahoma City in Oklahoma? ? Oh, yeah.
Law self-defense member Kansaki asked, do you think the Arbery case has a chance on appeal?
Oh.
Appeals are for losers. So instead of all the legal presumptions being in your favor at trial, where you're presumed innocent until proven guilty, now all the legal presumptions are against you.
Even if somehow they could win on the state case, they got the federal, so no.
Right, and then you have the federal on top of that, which is so even if you win on the case, the feds still have you. No, I think it would be very, very difficult. And let's face it, especially the way they've been demonized. It's not like there's going to be there's no like NAACP to help people like the McMichaels. There's no innocent project for the McMichaels. All right, let me see if there's any super chats. If not, I may just replay the opening statement from the trial. If I've caught up on all the questions. Yeah, let me see if I can. I think I have that geared up.
Always do a Supreme Court react and respond to some sort of oral argument. Something that we could cover.
Let's see. All right, so let's do a replay of the opening argument from the beginning of the trial while we're still waiting for a verdict to come in. So this will be Prosecutor Diener. That's the female with the gaudy necklace. And you'll see that this opening, it's only about 15 minutes long. And it's almost nothing but emotion, very little law. I think one paragraph out of the entire thing actually is a correct statement of law in this case. It's all sentiment, heartstring pulling, and so forth. So let's give it a quick listen.
That intentionally, with intent to cause serious bodily injury Atatiana Jefferson.
I hear the defendant being asked to plead guilty or not guilty to murder.
Shooting Atatiana Jefferson with a deadly weapon, to wit, a firearm, and thereby caused the death of Atatiana Jefferson. Signed the form of the grand jury. Yes, the peace is in his state.
Mr. Dean, to this charge, you may plead guilty or not guilty. What is your plea?
Not guilty, Your Honor.
Thank you, sir. You may be seated. Does the state wish to make an opening statement?
We do, Your Honor.
Ms. Dean? Okay.
Unfortunately, I think this part of the trial has a lot of coughing. Sorry, folks. Yeah, by the way, Law Self-Defense member Kansaki notes in the Law Self-Defense member chat that he's about 20 questions in today. If that was super chats, it'd be $100. He'd have had to have paid to get those questions answered. So you can pay $5 minimum for a super chat and I'll answer it, or you can become a Law Self-Defense member. Don't even have to be a platinum member, just a regular member, less than $10 a month, folks, less than $10 a month. And you get all of your questions answered for no additional cost. So I don't know why people insist on giving YouTube, giving super chats of $5, $10, $20 when YouTube's taking a third of that money and you're only getting one question answered. When for about 30 cents a day, you get all your questions answered. And you can become a Law of Self-Defense member right now, instantly, at lawofselfdefense.com/join. Go to the member dashboard, ask any questions, however many questions you want in the chat, and get them answered for no additional cost. 30 cents a day instead of $5 a super chat. There are, every once in a while, by the way, one of you will ask a question about my business, like how much money do I make? Those don't get answered, folks. I'm a private business. But self-defense law questions are what you get answered. All right, back to the prosecutor Diener. Miss Box of Wine.
Ms. Diener, you may proceed.
Thank you. May it please the court.
Yes, ma'am.
The last words that Atatiana Jefferson heard before she died was, "Put your hands in. Show me your hands and see." About a second. You're going to hear that after those things were yelled at her, the bullet went through her back bedroom window, into her chest. She fell down, face down. And you guys are going to have an opportunity to see and hear exactly what happened next. She says, "Oh my God." And then the next thing that you're going to hear, that Atatiana heard, the last noises she ever heard, were her 8-year-old nephew, Zion, his cries. Because when Atatiana Jefferson, just 28 years old, died in her bedroom face down, she was not alone. Her 8-year-old nephew, Zion, was there to watch. Now, this is not a case that deals with rival gang members shooting each other. This is not a case about a drug deal gone bad or a robbery. This is a case about a Fort Worth police officer, a stranger to Tatiana, who shot through the back of her bedroom window in the middle of the night. And she was in her home and should have been safe. You are going to hear that this is an absolute intentional act, an unjustifiable act that never should have happened. You're going to hear throughout the course of this trial from multiple witnesses that are going to talk to you about what happened in this case. They're going to hear and talk to you about what happened and how we got to Tatiana taking her last few breaths in her home. So how did we get here? What happened? So we go back. October 11th. Atatiana was killed, murdered by this defendant on October 12th of 2019, around 2:33 in the morning. So we back up to October the 11th. So October the 11th.
That's as loud as I can make the
started
court,
over Atatiana
folks.
and Zion very similar than a lot of other days. So you guys are going to learn a little bit about who Atatiana was. Atatiana was 28 years old. She had 3 siblings. They're right over there. Amber, Ashley, and Darius. Call himself the 18. Tatiana's mom, Yolanda Carr, she lived in the house with Tatiana off 1203 East Allen, east side of the building. And Zion lived there too. So Tatiana, raised in Dallas, went off to school at Xavier University, graduated her biology degree. After that, you're going to hear how she came home. And in 2019, she had moved in with her mom, Yolanda Carr, off East Allen, to take care of her mom's failing health. She was also there to help take care of Zion, help raise him, because at that time, Amber was having some severe health issues with her heart. And so Tatiana was living there at that house, helping raise Zion, teaching him the responsibilities, day-to-day chores. And you guys are going to hear on October the 11th, just a regular day, that Tatiana had taken Zion outside. He's 8 years old at this time. And let me tell you, Zion's very rambunctious and energetic, as many 8-year-olds are, right? And you're going to hear from witnesses that will describe neighbors across the street that saw Tatiana and Zion outside, her trying to teach him how to mow the lawn. So this neighbor sees Zion running across the lawn, pushing a lawnmower, trying to learn how to veg. After that, on October the 11th, they went inside and they had dinner that night. They burned the hamburgers they were making in the kitchen. So there was smoke. So both the front and the side door of this house, they opened to let that smoke go out. Both of these doors also had storm doors, kind of like those storm doors that they'll have, it's either screen or glass. That was kept shut, but the main door, the front and the side, were open to let that smoke go out. So at this time, Yolanda had been in and out of the hospital. And on October 11th, going into the 12th, she was in the hospital. And unfortunately, Yolanda has since passed away. So in that house that night, there was a Tatiana and her nephew. So once they go to bed, they go into Tatiana's bedroom, and you're going to get to hear about Tatiana and what she liked to do. She was studying, wanted to be a doctor. She was working, taking care of Zion, her mother, her family. She also loved to play video games, loved to game. She would get on the computer, play video games with Zion. That's what she loved to do. In fact, her siblings would poke fun at her for playing video games all the time, just what she liked to do. So that night, Zion goes to bed. Tatiana's in her back bedroom. They're in her pajamas, barefoot, comfortable. They're supposed to be safe. But you're going to learn that around 2 o'clock in the morning or so, Zion, who's asleep in her bed, he wakes up at some point throughout the night, and he sees his Aunt Tay, which is what he calls her, is still playing video games, and she's up. So 8-year-old says, I want to play too. So he gets up and he starts playing video games with her. So they're laughing, having a good time. Tatiana and Zion had no idea what was coming. They had no idea that across the street, James Smith, a neighbor, had called the non-emergency number to Fort Worth because he saw and noticed those two doors were open, that front door and that side door were wide open. Lights are all on in the house. Both cars are in the garage or in the driveway. But that's unusual for those doors to just be wide open. It's a dark, really cold night. And so when the call comes through, he calls the non-emergency number, gives them the information, tells them when asked if the neighbors are home, he tells them, well, both cars are in the driveway, and he describes them. He says that his doors have been open for several hours. I just want to make sure everything's okay. So when this defendant and his partner, Darch, her name is Carol Darch, and you're going to hear from her. Carol Darch and this defendant go in their patrol cars, two separate patrol cars, show up around the East Allen area. They actually park right next to a house that they believe to be 1203. They went to the wrong house first. There was a house just down the street, kind of diagonal from where Atatiana lives. And you guys are going to have an opportunity to see maps, photographs, and hear testimony from these witnesses, so you better orient yourself as to what we're talking about. So they park next to this house on the side, and then no lights, no sirens. They then go across the street, and unbeknownst to them, James Smith, that neighbor who had called, and his family were all sitting outside on the stoop, making sure everything was okay. Because they knew this house has a woman by herself and a young child. And the one thing you're going to learn about James Smith is he and his family own multiple houses on this street of East Allen. East Allen's a little bit of a niche inside of the east side. East Allen, a 1200 block where Atatiana and her family lived, across the street, there are multiple houses, and those all belong to James Smith and his family. Right next door to Atatiana is an old church or mosque. Okay? There's no other houses right next to her. To her left, looking at the house to the right, if you're coming outside the house to the left, you guys are going to see a very big lot, an open lot. Okay? So James Smith is the kind of neighbor that we all want. He's the kind of neighbor that pays attention, looks out for us. James Smith has lived in this area, and y'all will hear from him and learn this for 60 years. He's kind of like the mayor of this particular street, right? He's the guy that tells you your package is on the front door. He's the guy that watches out and knows everything about the neighborhood. He actually takes a particular amount of pride. He's like the guardian of that particular area. He had called the non-emergency number before. Y'all hear about that. So he's outside along with his other family members that live in all these houses, and they're watching. They're waiting for the police to show up and pull up and check. But they don't ever see a patrol car go to the front. They don't ever see lights. They don't ever hear anyone identify themselves. What they see is two figures go diagonally across the street, go up to the front door, peer inside, go to the side door, peer inside. And you guys are going to see they don't announce. They don't knock. They don't ring the doorbell. They don't step back and call for backup. They then go from the front to the side. They check either of those doors, those storm doors, to see if they're unlocked or locked. They then continue onto the side, walking right next to Atatiana's white car. They continue, and this defendant goes wide to the right of Yolanda's car. It's in that driveway. Darch, his partner, goes between the car, the dark car, and the house. And there's a bicycle right there. And Darch kind of hits that bicycle. It's Zion's bicycle. It's his bicycle. And at this point, Tatiana, who's sitting at her computer desk playing video games, hears something outside. To this point, she had no idea that the Fort Worth Police Department had even been called. And so you guys are going to learn that as she's sitting in her computer desk, she thinks, oh my God, it's your worst nightmare, right? Somebody's trying to break in your house, in your backyard. You're by yourself, and you got Zion. So she goes to her purse, gets the gun out that she owns, and she walks up to the window with her gun, and she's looking outside. She's got her gun out, she's looking outside. She's going to hear from Zion, who was inside.
I just want to point out here that one of the things that the state strongly contested was that she was pointing her gun out the window. Even though the officer defendant said he saw the muzzle of the gun, the 8-year-old who was present said his aunt pointed the gun at the window. And right here, the prosecutor is reenacting her pointing the gun out the window.
Coming around and looking at the back gate of that backyard. The defendant then proceeds to open that back gate.
See if I can get closer.
So as she goes up to the window, as she's looking outside, this defendant goes into the backyard, stands in front of the window.
Oh, come on.
The backyard. Tatiana sees flashlights. She's now heard noises and sees flashlights. She thinks, I'm going to have to protect us from whatever that is. She had no idea it was someone that is supposed to serve and protect. So as she goes up to the window, as she's looking outside, this defendant goes into the backyard, stands in front of the window. And you're going to see on this body camera that he turns, something catches out of the left of his eye, something catches. He sees something, he turns, and you will hear, put your hands up, show me your hands. And I'm talking about, show me your hands, put your hands up. It is not fast enough for Tatiana to process and follow the commands of an unknown stranger in the backyard, let alone fast enough for him to see anything in her hands. When you watch this body camera footage, pay attention to what this defendant says, what he does, what he doesn't do, and what he doesn't say. Because that's very important to this particular case. And we're going to watch the video over and over again throughout the course of this trial. So after this shot is fired, immediately his partner, Darch, says, we got to get in there. We got to get in there. Dean, we got to get in there. So at that point, they go from the backyard, out the gate, around the cars, side of the house, back to the front, through the carport, in the front, in through the front door, start going through the house, straight inside, and you'll hear Darch say, put your hands up, Fort Worth Police, starts to finally announce as they're getting through the house into the back bedroom. The entire time that that is happening, you will not hear this defendant ever say, go. He said, show me your hands, put your hands up. He didn't say drop it. He didn't say gun. And if they're about to rush into this house, he did not warn his partner that he didn't see anything. So they go into the house, they rush to the back bedroom, they find Zion on the bed, hysterical. Tatiana is face down. Darch immediately takes Zion from that room, takes him to the next room to get out. And so what does the defendant do when he gets in there and sees her? He doesn't do CPR. He doesn't put his hands over her chest to try to save her life. He doesn't do any of those things. Instead, what he does is he's looking around the room. His flashlight comes upon Tatiana's gun. When we play that video,
Folks, I see someone in the comments, Catherine Bedford, saying this was a welfare check, not an open structure call. That's not correct. It was an open structure call, not a welfare check. Incontroverted testimony.
guys to listen to the side and what he said next. Looks like we got that. Thank God, right? The evidence is not going to show you at any point throughout that entire video that you watched that he ever says anything about seeing the gun. And when you watch that video and you see how fast this happens, there's no way. There's no way. So after they get inside, and he is looking around, he starts playing with her gun, trying to figure out how to turn off the light of the laser, trying to figure out how to disarm it, sets it down, still not providing any kind of CPR or life-saving measures to her. And it's not until you hear at the very front, because they've called for medical help and other backup, when he hears those first few officers show up at that front door because they announce Fort Worth Police, you're going to hear him say, "We're back here." And it's at that point he grabs a blanket and finally puts it on her chest. But it's too late. And it wouldn't have mattered.
It was too late. The bullet passed through her heart.
Yeah.
I mean, not to put too fine a point on it, but it didn't matter.
So they perform life-saving measures and they spend 20 minutes trying to save her life. They did everything possible. But they could not save her. She is pronounced. It's at that
Bullet
point
through the heart
you're
will
gonna
tend to
hear
do
about
that.
the investigation and what happens after that. You're going to hear about how Darsh, his partner, when all the different supervisors, the entire Fort Worth Police Department shows up out there at the scene, that Darsh does what's called a walkthrough of the scene. This is something that is done in police shootings. So she goes through and does a walkthrough. Here's where this happened, here's where that. She does not do that, though, until she gets the benefit of having her plea attorney there. When I say plea attorney, I don't mean these two folks, not criminal defense attorneys, but attorneys that are provided to law enforcement by the associations. They get the benefit of having that attorney show up and be with them right after the shoot. So she does a walkthrough, explains what she has seen, what happened, or what she remembers. She's put into a patrol car, and then she is taken to the major case unit, which is a part of Fort Worth Police, and they investigate police-involved shootings, any incidents involving police. So the major case department has that particularized knowledge and training, and they handle these cases. So they did their own investigation. They interviewed Darsh 2 different times, went through what happened. They looked at that video over and over and over again, frame by frame, slowed it down. They met with multiple witnesses, medical personnel, went out to the scene. The crime scene is going to testify. They're going to talk to you about what they did out there at the scene. You're going to see a bunch of different photographs so that you guys can really see and envision this house and this backyard. They took measurements. They collected the guns from both from her house and from the defendant. And you're going to hear that after Major Case interviewed all of those witnesses, reviewed the 911 calls, the video, looked at all the photographs, were out there at the scene, that they determined that there was sufficient probable cause for an arrest warrant affidavit to be given to a felony district judge, just like this judge. And that judge signed an arrest warrant for this defendant to be arrested for murder.
That's really a sign of how little this the state has to work with here. They're trying to suggest that the arrest warrant, the fact of arrest and charging, should lead automatically to a guilty verdict here. Judges sign any warrant that's put in front of them, folks.
Oh,
At the conclusion of this case, after you hear all of the witnesses that are going to testify, you listen to that 911 call. You look at those photographs. You watch that video as many times as you need to. Thank God we have it. After you look at all of the evidence in this case, you will be sure, beyond a reasonable doubt, that this is murder. You're gonna know that this is not self-defense. This is not a circumstance where they're staring at the barrel of a gun and he had to defend himself against that person or to protect against his partner. The evidence will support he did not see the gun in her hand. This is not a justification. This is not a self-defense case. This is murder. Your home is supposed to be the one place on earth that you get to go to be safe, to seek shelter, to seek refuge. But for Atatiana Jefferson, her home was not her refuge. It was not her sanctuary or her safe place. It was her demise. And she left in a body bag because of what he did. And so we're going to ask you to hold him responsible because that's what the law and the evidence demands. Thank you.
now I suspect we may disagree, but I find that speech to be rhetorically persuasive. I find it to be the intonation, pacing, timing of the elements, vocal variety. I mean, it's not the best I've ever heard, but I find it to be very, very competent.
Well, I mean,
it's light on
it's
legal
an
analysis,
opening.
but it's a good persuasive speech.
It's opening. You know, there's lots of discretion for them to set out the narrative that as they want to share with the jury. They know it's going to be a self-defense case. Obviously, she doesn't attack any of the elements of self-defense except to suggest he never actually saw a gun, which is really inconsistent with the overwhelming weight of the evidence. He says he saw a gun. The victim's holding a gun. The 8-year-old says she pointed the gun at the window. He ended up firing a shot, which would be consistent with him seeing a gun. He didn't fire instantly. He gave a command and then fired, which would be consistent with him seeing a gun. We're supposed to outweigh all of that by drawing a negative inference from the fact that he didn't later say the word gun when he went into the house. I don't find that particularly compelling. She made no other real argument counter to self-defense, but of course she has the whole trial to do that. Here, all she really has to do is summarily say, we will show you that it wasn't self-defense. She doesn't have to do that here. So that's fine. But I found it very, heavy on rhetoric, light on law and evidence, which is not super inappropriate for an opening. But if I were going to attack someone's claim of self-defense, I'd mention in opening exactly what I was going to prove to them. Say, we're going to show you that he was the unlawful aggressor. We're going to show you he used disproportionate force. We're going to show you that he didn't retreat when he safely could have and would have been legally required to. Whatever I think the primary defect in that self-defense claim is, I'd point it out, because that's one of the things you should do on opening too, is tell them what you're going to show them so that they're aware of what to look for as you get there. But she doesn't actually have any of that, except for this.
Right.
They're supposed to draw this negative inference from the fact that he didn't say gun, which I at least don't find compelling. But again, the defense too could have addressed that, and they didn't. They could point out all the way to the evidence that's consistent with him seeing a gun, and the weight of that. But they were never very effective at countering these rhetorical arguments by the state. They were never very on point with that. It was almost like they were in a different courtroom making different arguments, just things they'd planned in their head, make sure we say our things, but not being effectively responsive to the stuff the state was throwing out there.
Yeah.
Let's see if we have any questions that came in. Yes. Okay. Law Self-Defense member Chris asks, Andrew, is there any sort of book that would help me understand the principles of the law of self-defense? As it happens, there is. There's, in fact, the Law of Self-Defense Principles, softcover book. Check out the reviews on Amazon, folks. Law of Self-Defense, 5-star rated, over 1,200 reviews, very well received book, but don't buy it on Amazon. They'll charge you $25 plus shipping and handling. We'll give you the book for free. For free. We'll eat the $25 cost of the book. We'll only ask that you pay the cost of shipping the book to you. So cover the shipping and handling. We'll send you the book, real book, not just a PDF download, real book. We'll send it to you for free. Just cover the shipping and handling. You can do that at lawofselfdefense.com/free book. And during this holiday season, if you have loved ones you'd like to help keep out of jail, if they're ever out of prison, if they're ever compelled to defend themselves, their family, or their property, a lovely gift would be the beautiful hardcover version of that very same book. This one's not free. The hardcovers are too expensive to print up to give them away for free, but they're lovely gifts. They look great on the bookshelf, and they might keep your loved ones out of prison. You can get this book at lawofselfdefense.com/gethard. lawofselfdefense.com/gethard. Thank you, Chris, for reminding me to grift. Let's see. Chuck says, question. Oh, it's not really a question. He says, Andrew, I'm going to send you some Texas wine after Christmas. Be on the lookout. All right. I'll be on the lookout. I don't know if I can drink it, but we'll see. Kansaki, Law Self-Defense member Kansaki says, question, can the prosecution actually say the defendant murdered someone during opening? Isn't that coloring the event? No, they can say that that's what they intend to prove, is that this was a murder. That's perfectly fine. More objectionable is what this prosecutor did on closing when she argued to the jury that it was never a question in this trial whether or not this was murder. Well, yeah, that's actually the whole question in the trial. It was never a question if it was an intentional killing. That would be fair to say. He always said, I shot her intentionally. But an intentional killing is only a murder if it's unjustified. So whether it's murder is an open question. That's for the jury to decide. And by the way, if we all concede and agree and stipulate that it was intentional, well, then it wasn't reckless. So, because recklessness is an unintentional killing. Let's see. Law Self-Defense member Old Bill says, question, unrelated to today's topic, as an instructor who teaches concealed carry classes in Florida to meet state requirements, at what point would I trip over the line and commit unlicensed practice of law? Yeah, don't do that, but it's not that hard to avoid. Don't tell people what to do, and don't tell people what a legal answer would be. You might suggest to people, these are the issues you might want to consider. These are the factors that may play a role. Obviously, I'd make clear to them, you're not a lawyer. But you start getting in trouble when you start giving people legal conclusions or legal analysis to guide their behavior. You ought not do that, but you can certainly point them at the things they may want to think about as being important in that analysis. Maybe avoidance is relevant here. Maybe proportionality would be relevant here. That's just hypothetical discussion. And by the way, if anybody ever comes up to you and says, hey, I was actually involved in this event and I'd like to talk about it, then I would avoid that. I don't talk about people with people about that kind of stuff. If I'm teaching, out of state and they want to talk about a specific event that happened to them, I only address hypotheticals. If they want to talk about a specific case, then it's a legal consult. And in my case, they'll need to have retained lead counsel someplace and have their lead counsel call me. Let's see. Paul, Law of Self-Defense, member Paul says, the thought of going to trial scares the bejesus out of me. You get lawyers like these and you're screwed. Yep. You don't want to be at the mercy of lawyers of questionable competency, especially when the rest of your life in a cage is at stake. Robert Cornell, Law Self-Defense member Robert asks, why not eliminate opening and closing arguments by eliminating lawyers' ability to prejudice the jury with misstatements of law? Why not just bang the gavel and start questioning witnesses? Well, because you want all the testimony that happens in the trial proper to be in some kind of context. People need to know why they're there, what's being argued, What's the narrative of guilt? Just the framework of it. What's the narrative of innocence? The framework of that. So when they start hearing people's testimony, because otherwise the testimony is all in isolation and out of context, and it's very difficult to know what to look for, what to pay attention to, what you're supposed to be evaluating. So no, I would never advocate getting rid of opening and closing. I mean, the jury's told opening and closing is not evidence. It's just to frame out the narrative of each side. There's still things that can happen in opening and closing that would be objectionable, like misstatements of law. I didn't hear that here. She did a ton of that in her closing. But the opening was mostly emotive. I mean, I couldn't find the frame in the video where she's holding up her hand like a gun pointed horizontally, which is, of course, consistent with the narrative of innocence by the defense. But it's in there. I'll screen capture it when I have an opportunity. Let's see. Yeah, so Jeff asks, law self-defense member Jeff asks about the Arbery case. What was it that got Roddy Bryant convicted? Is it true that all he did was film? So the state argued, and this may have been true, that Roddy Bryant used his vehicle to block Arbery's path of escape or something. And in the course of that, a reasonable person in Arbery's position would have been frightened by the proximity of the vehicle, and that would have constituted an assault. An assault is a felony. He died. I don't remember if they got the felony murder with Bryant. I don't think so, because his sentence.
They didn't get the malice murder, and they didn't get the first felony murder, but I think they got the other three. So they got the assault, the second assault with the truck, which was when he tried to run him off the road. Then they got him for the false imprisonment with the trucks. And there was a third one in there. But they didn't get him for the malice murder, and they didn't get him for the felony murder for the underlying assault with the shotgun. Yeah,
right.
That's right.
So
6 out of 9 counts.
Right. So he wasn't convicted just for filming. I mean, you have to believe again, but if the citizen's arrest has been lawful, if you're allowed to arrest someone, you're allowed to pursue them. If you're allowed to arrest someone, you're allowed to constrain their liberty. It's not unlawful imprisonment if it's a lawful citizen's arrest. So again, even with him, whether or not the citizen's arrest was legit is the key to everything. Let's see. Law self-defense member Kyle asks, for those of us with a limited budget, maybe grift all of the free resources a member gets at any level. I uncovered a ton of instructional videos you have for members. Yeah, so even just the basic membership, the less than $10 a month, folks, you get access to thousands probably of hours of my videos, my content, my podcast for members only. A lot of the content's
cool.
Members only. It's locked down. It's not like you're just getting what you're seeing today. It's all on the blog, years of content on all these cases. You watch and listen to all that stuff, and if you don't gain an expertise in self-defense law, you got dropped on your head as a child. I mean, it's all there. Me talking about it just about every day. So there's a ton of content. Frankly, the easiest thing to do is just become a member for less than $10 and try it out. I mean, if you don't like it, you're out $10? I mean, if you don't like it, our policies will actually refund all your money. So it's a zero risk opportunity. Just sign up as a member, lawselfdefense.com/join, and go to the blog and check it out. Sign in and check it out. There's tons and tons of stuff there, including mini courses on self-defense law, all kinds of stuff. All right, law self-defense member Kansaki. Question, hypothetical, Andrew, you are on trial for self-defense, bench or jury trial, and why? You have the choice, and the prosecution must accept. Yeah, so normally you can't compel a bench trial as a defendant. There's a couple states where you can. Maryland is one. So in the Freddie Gray prosecutions, those 6 officers who were charged in the death of Freddie Gray, even though there was zero evidence any of them did anything wrong, but 6 officers were charged with crimes as serious as murder. They were able to compel a bench trial. In Maryland, if a defendant wants a bench trial, there's nothing the state can do about it. In most states, they treat it as if not only is the defendant entitled to a jury, but the state's entitled to a jury too. So the state has to agree to a bench trial. But let's pretend you can demand a bench trial and get it. The legal cliche is if you're guilty, you want a jury trial. And if you're innocent, you want a bench trial. Because if you're guilty, You're hoping your lawyer can sway at least one of the jurors to not be convinced beyond a reasonable doubt, and you get a hung jury. Or even better, sway all of them, and you get an acquittal. But you're relying there on the being able to appeal to the emotions of the jury in your favor. If you're innocent from a technical perspective, the prosecution will try to do the same thing with the jury, like they did here. And you don't want that risk, in theory. If you're innocent, you'd prefer to have someone who's not going to be emotionally engaged in the legal analysis. You want a legal technician, which would be the judge. And you argue strictly the law and evidence to the judge, and presumably the judge would come up with a just response, answer out of that legal algorithm. Of course, judges are subject to political play too. So it's not by any means a guaranteed thing. If it's a politically energized or racially energized case, the judges don't want to hold that hot potato either. Although I have to say in the Freddie Gray prosecutions, so of course, Freddie Gray was, are we back? Let me take a look. Nope, they're still doing a replay of prior testimony. Freddie Gray was black. He was basically a street corner drug dealer in an open air drug market in Baltimore. The prosecutor, Marilyn Mosby, the state's attorney, her husband was the local, like, city level politician for that part of the city. And he'd been getting complaints from the residents about this open air drug market. So he asked his wife, state's attorney Marilyn Mosby, to ask the cops to do a sweep through this drug market, which is why Freddie Gray got arrested. He was part of that sweep. The cops, he ran, the cops chased him, tackled him, searched him, found an unlawful knife on his person, which a knife much like this one, just an assisted opening knife, which is illegal under Baltimore law. People were caught and prosecuted for that charge all the time by Marilyn Mosby and her office. So they arrest him with the knife. They handcuff him. He's non-compliant with arrest, so he gets a little roughed up, but nothing serious, certainly nothing to his neck. And they put him in the back of a police van, and the police van travels to its next destination. And when it gets there and they open up the van, Freddie Gray's got a broken neck. The medical examiner's first report says it's a shallow diving type of injury, which would be consistent with Freddie Gray standing up in the moving van. And then you got to kind of hunch over in this thing. It's got a very low ceiling. And then the van brakes for a stoplight or for traffic or whatever. And we all know what happens if you're on a moving vehicle and you can't hold on to anything and it changes direction or velocity. You tend to fall over. Probably the van braked, and with his hands cuffed behind him, he fell forward, smacked his head against the bulkhead of the paddy wagon, so to speak, and suffered a neck injury. No one did that to him. It wasn't a result of any intentional force. They tried to claim he was given a rough ride in the van, but there's surveillance video of the van traveling, and nothing like that happened. By the way, the driver of the van himself was a black man, so there wouldn't be any racial motive there for him to give Freddie Gray a rough ride. Nevertheless, probably, I suspect, to avoid the embarrassment if people discovered it was Mosby herself who requested this drug sweep. By the way, the Baltimore Police Department did a thorough investigation, and they were that day supposed to announce no charges. And about an hour before the police made its announcement, Marilyn Mosby abruptly called a press conference in front of the courthouse and announced a whole slew of charges against 6 of these officers, as serious as murder charges against them, claiming that she had run an independent parallel investigation with investigators out of her office. Later on, she would be sued by the police officers, and it would be disclosed. What if she got sued and her lead investigator got sued? And the lead investigator responded to his subpoena by saying, "I don't know what you're talking about. There was no parallel investigation." No, she just made it up. It was a complete lie. But based on that claim of a parallel investigation, she got these cops charged. The first cop, who also happened to be a black male, got a jury trial, and the jury hung. So it was a mistrial. He was going to be tried again. Every other police officer tried, demanded a bench trial. And by the way, not that any of this should matter, but that's the world we live in. The judge, who was the same judge for all these trials, was himself a black male. So they gets a bench trial for the first officer, and the judge acquits him, as he should have, because there was no evidence the cop did anything wrong. The second cop, bench trial, same judge, acquittal. Third cop, bench trial, same judge, acquittal. And at that point, the evidence for all these cops is the same. It's the same event. Nothing's going to change. And finally, the prosecutors gave up and they dismissed all the charges against everybody involved. So for those cops, they saw what happened with the first guy. He didn't get acquitted. He got a hung jury. And they thought, you know what? I know I'm innocent. I didn't actually do anything wrong. I don't want to get convicted by a scared jury who thinks, you know, when they go back to their community, there may be repercussions if they don't convict, or convicted based on emotion, like happened in this case here with Aaron Dean. I'm going to get a bench trial. And that worked for them. That worked for them. But, you know, you definitely want to talk to your local lead counsel about that judge, because there's lots of judges I would not want to be a defendant in a bench trial in front of.
Very good point.
All right, let's see. Law self-defense member Robert, question, doesn't it appear that the jury convicted based on the prosecutor's misstatements of law in their closing arguments? I certainly didn't see credible witness testimony supporting the prosecutor's storyline. Well, it's kind of interesting. The most explicit misstatements of law had to do with self-defense. They grossly misrepresented what self-defense requires. But nevertheless, the defendant, Aaron Dean, was not convicted of murder. So self-defense, the jury bought self-defense. If he said, I intentionally shot her. If they didn't buy self-defense, that's just murder. So self-defense still worked, even though the prosecution misstated self-defense. So I'm not sure that's what caught him, given that there was an effective acquittal on murder. He got convicted on reckless manslaughter. And there, I think the misstatement of law was more subtle, because the prosecution never pointed to reckless conduct proximate to the use of force, like the way he handled his gun or something like that. It was all things that were unrelated to the actual use of force, like how he walked across the street to the house, how he approached the house, how he approached the front door, how he sliced a pie on doors, how he used his flashlight to inspect the cars. They pointed to lots of things they said he did wrong, lots of things he said he did wrong on his own cross-examination. But none of them are relevant to reckless manslaughter, because none of them had anything to do with the actual use of force. But the defense never pointed that out. They just left all these, I did that wrong, I did this wrong, I grade myself a B stuff out there. And the jury may have been under the impression that anything that could be characterized as reckless could be grounds for a finding of reckless manslaughter. So that was a more subtle misrepresentation. So that might well be, if you ask the jury, they might say, well, you know, he didn't cross the street, right? And they might have thought that was sufficient for a finding of reckless manslaughter. And that's on the defense. The defense should have explicitly said in their closing, listen, you heard the defendant say there's things he wished he had done different, but none of them led to the death of Atatiana Jefferson. Crossing the street didn't kill her. The way he looked in the door didn't kill her. The way he inspected the car in the driveway with his flashlight, that had nothing to do with her death. So all of that is irrelevant. But they never made that clear to the jury. So I think the jury was just misled by he said 30 times, I could have done that better. Collectively, it's like a collective recklessness that perhaps provided an excuse for the jury that may emotionally or politically wanted to find a conviction. It gave him an excuse, a hook to hang that on.
I mean, proximate cause is hard. I mean, it's something that you know, takes a little bit of trouble getting used to as a lawyer. You know, how far down the chain of causation you can go,
right?
And how close you have to be in sort of in time.
And it's not just but for. I mean, people often mistake it as being a but for requirement. But for this, it would not have happened. But that's not useful, because but for him reporting to work that day, it would not have happened. But for him responding to the call, it wouldn't have happened. But for him, I mean, of course, the event happened. So there's lots of things that preceded that, but they're not causal. None of them led directly to her death, were proximate to her death. But yeah, unless you explain it to a lay audience, that's how they'll think about it, right? In a but for sense. Let's see. Yeah, so Jeff writes, law self-defense member Jeff writes, interesting note, in the Freddie Gray case, the medical examiner ruled homicide in that case as opposed to accident. Well, she wrote 2 medical reports. So she wrote a report that was accident, and then she got a call from Marilyn Mosby, and she wrote a second report.
Ooh.
Yeah.
Wow, that's not good.
Someone had asked about the toxicology.
That's going to kill your prosecutorial immunity right there. 'Cause you're
Oh, it
going
didn't.
outside your prosecutorial function. That didn't do it?
Yeah, so no, they sued her, and it was revealed that the second report, based on presumptively on her call, is why the report was changed. But this whole fabricated parallel investigation that never happened. But when they sued, the courts threw it out. Immunity, prosecutorial immunity, was not pierced.
Okay.
Now she's got all kinds of trouble. I think she's in trouble with the feds for some kind of monetary fraud thing going on. But that's not self-defense, so I haven't followed that. But I think maybe maybe karma is catching up to her. Let's see. Yeah, another problem, of course, with all these misstatements of law that happened in this case, almost none of them, I think only one, but none but one were objected to by the defense. So if they're not objected to, folks, they're not preserved for appeal. So it's crazy. I don't get it. I couldn't believe it. And there were a lot of running objections in this trial, but running objections they're not cool. So a running objection is, someone's doing something wrong. You think the other side's doing something wrong, and they're doing it over and over and over again. And you don't want to object every single time. You don't want to object to every sentence. So you object the first time, maybe you say hearsay, improper argument, whatever the case might be. And then you ask the judge for a running objection, meaning I'm just letting you know I'm objecting to every one of these things. And trial judges may allow that because they don't like a lot of objections. It disrupts the flow. It takes a lot of time. It's just not nice in the courtroom for the operation of the courtroom. The trouble is, even though the trial judge allowed a running objection because it was convenient for him, if you have to appeal, the appellate courts hate it because they want to respond to specific questions of law. And if it's a running objection and it's not specified what each objection was at each moment in time, they have to kind of guess at what the objection was or guess what you're objecting to specifically. And they just don't want to do that. And sometimes something could happen and there might be 5 reasons it could be objectionable. And they don't want to do the analysis on 5 when you could have specified in the moment which one you were concerned about. It's just too much work for them. So often the appellate courts they'll say running objection. We don't give a shit about that. It's all waived. It's all waived. And you can't look back at your trial judge and say, well, he allowed it. They don't care. They don't care. Let's see. Let's see. Super chats. See if there's any super chats I need to answer. Let's see.
By the way, I know I never said it otherwise, but as long as I'm here, I might as well say that I was sorry, whatever it was a week ago or something when I was short with you on that stream. Because
I don't care. It's fine. I didn't take it personally. I know. I did see someone made a big deal out of it. I guess they cut out that part of the show and made a whatever they call a law nerds clip or whatever. Don't worry about it, Kurt. I don't take that kind of stuff personally.
Yeah, well, when I make a mistake, I like to say I apologize.
Well,
so I'm sorry.
I appreciate it. That's good character. Most people can't do that. Let's see, $5 super chat from Nancy Jennings. At 2:30 a.m., why would you leave a door open, not secured, when you have the responsibility of the safety of a child? Yeah, I mean, okay, but that's not actually the right legal question, right? The right legal question is, having a door open at 2:30 a.m., is that enough to create reasonable suspicion that may lead a police officer to want to investigate further? And it does. And that's all that was happening here. So it wasn't like he went up to an apparently safe, secured home and decided to investigate their backyard for no reason. He was responding to an open structure call, which is treated as a silent alarm call, which is treated as a burglary in progress, possible burglary in progress call. He gets up to the house, the doors are open, he looks in the house, and it looks ransacked. There's shit everywhere. So it looks like it could be a burglary in progress. So he goes to the next step in the algorithm. All right, investigate the outside of the house, look for signs of forced entry. And that's what he was in the progress of doing a minute later when he was looking at a gun and drew his own pistol and fired. So there was more than enough there to provide for reasonable suspicion, exigent circumstance to investigate a possible burglary in progress. And it doesn't matter what the mental state of the homeowner was. It doesn't matter that the homeowner may have had what they thought was a perfectly good reason to leave the doors open. That's not the question. The question is, how could it be perceived by a reasonable police officer responding to that call? Red Beanie, $5 super chat, writes, what's your opinion on the upcoming contempt hearing for the mayor and a city council member for their outburst during the verdict reading? I didn't even know that's what the outburst was about. I know people got chastised by the judge afterwards. And I don't do contempt stuff. So whatever the judge wants to do is fine with me. I don't think he'll do anything, by the way. Normally they yell at you about contempt and that's it. Very rarely is there a real consequence. Phil Moore, $5 super chat, says, do you think Soros paid off the defense, or maybe they were intimidated by activists? It's awfully suspicious. No, I wouldn't. I have no reason to believe that. I just don't think they did a good job. That's it. I don't know. I'd have to see a lot more evidence before I would conclude that it was deliberate incompetence. That would be pretty bad. Let's see. Robert, Law Self-Defense Robert asks, question, is it illegal for an officer of the court to knowingly lie to a jury? Well, if you mean a lawyer to lie to a jury, it's certainly improper. Is it perjury? I mean, the lawyers aren't under oath.
No, it's a violation of rules of ethics because it's lack of candor to the tribunal. But then, of course, you have to deal with what you mean by lie exactly, because if you creative phrasing can often not be a lie, and failing to say something is not usually viewed as a lie. So if when you're thinking about a lie, you'd have to actually say something that's just blatantly false, which is most lawyers are more clever than that. But yeah, you can't just out and out lie to the tribunal.
So we just heard the defense opening. Let me see.
We heard the prosecution's opening. I don't think we heard the defense's.
Oh, sorry. The prosecution opening. Quite right. Now I have the prosecution closing with the buzzers. And I think I have the buzzers normalized now. So let me play that again. Whoops. See if it sounds any better. So what I did with Steve Gosney, Kurt, did you see this earlier? Were you here earlier when I played this? I don't think so. Okay. So we took the we took the state's opening, and I added a total number of improper arguments counter at the bottom, and a buzzer sound every time she made an improper argument. And then I would specify at the top of the screen the form of improper argument that it was, just to keep a running count. I did the first minute or so. Basically, her whole first 2 or 3 paragraphs are all, every sentence of it is improper. And I didn't put a buzzer in for every sentence because I thought that would be crazy. I ended up putting a ton of buzzers in later, though, because it just kept happening. So the first minute is kind of slow, but then the buzzes start coming fast and furious. Spoiler, more than 60 improper arguments in a closing that's only 15 minutes long, 14 minutes long. So quite a few. Let me pull this up. And we'll try playing it again.
If you can't feel safe in your own home, where can we feel safe? When you think about your house, you think about safety. It's where you go to retreat, to get away from the world. It's where we grow up. It's where we have kids. It's where we mark on the inside of a doorway, and they've gotten taller and taller. It's where we make memories. That's why it's so sacred. That's why it's so important. How many of us during the Thanksgiving holiday were in our own kitchens celebrating with our family? Christmas, right now, how many of us right now have a Christmas tree in our living room? Why do we do that? Why do we put Christmas lights outside our house? Why do we decorate our homes? Because they're ours, right? Because they're so important. And today, that's exactly why this day is so important. Because the sanctity, the safety of our homes has been compromised by what he did. He took her away, 28 years old, the rest of her life at the hands of this defendant. The Fort Worth Police Department has good officers. In fact, I've worked with some of the best officers in the state in my career. I trust them with my family. They actually do serve and protect. They don't have preconceived notions about the East Side. They don't go to certain parts of town and say some deserve to be served and protected, but not others. Only the good parts. Only the parts of town that I want to go to. That's not how it works.
But he went to that part of town, so what are you talking about?
And it was her too.
What's that, Kurt?
I was just saying, like she says, officers don't have luxury to only go to the good parts of town. But he went to that part of town, so what are you talking about?
It's a bizarre argument. She's simultaneously trying to argue some kind of implicit, maybe racial motivation here, because this is a largely black high crime part of the city, suggesting that he preferentially provides law enforcement services to the neighborhoods he likes, I guess the non-black neighborhoods. But in fact, it's not like he's in trouble for not going. He went to a apparent burglary in progress call. So it's incoherent.
Yeah, it's like that argument doesn't flow at all. It doesn't make any sense. That's why I was confused.
Despite what he thought, when he went over to that house, it was a dope deal gone bad, a robbery or a shooting, high crime area. This is a 28-year-old woman that was a daughter, a sister, an aunt, studying to be a doctor.
She was going to cure diabetes, so we'll never have a cure for diabetes now. But of course, all of this emotional stuff, you'd think we were in the penalty phase here, where this might matter. None of these facts have anything to do with whether or not he committed a crime.
Taking care of her nephew. Yolanda, her mom, was a good person. Zion was a good person. James Smith still lives on the east side. He's a good person. His family are good people.
So there's no evidence of any of this, that anyone's a good person. I mean, maybe they were good people. We don't know. But and in any case, it's irrelevant. What would matter is the defendant's subjective perceptions of what was going on in the moment. He's not required to know whether or not other family members, people not even physically present at the scene, or neighbors are good people.
When you put on that badge and you put on that uniform, you say you're going to serve and protect us all. That means her too. And the Fort Worth Police Department, those officers that do serve and protect us and don't have those preconceived notions, that did a thorough investigation in this case, are ashamed that they ever called somebody like him a brother in blue. Because
Zero evidence of any of this.
Ashamed? Who testified to being ashamed?
Not a single person. And believe me, if they had not liked this guy, they would have brought in cops to testify. I mean, they did that with Chauvin. They brought in plenty of people from the department to say, no, what he did was wrong. What he did was not the training. What he did was inappropriate.
it means something when you put on a badge. It means you don't go to a house with a preconceived notion because you want to have that kind of power.
They made a big deal out of this whole preconceived notion argument, but he was going there in response to an open structure call. I mean, he was going there in response to specific information he had. He just didn't imagine this.
Yeah, so his preconceived notion is it's an open
Haven't we all
structure.
met an officer that just likes being an officer a little too much? I've been pulled over by those guys before.
Zero
Power
evidence for this.
hungry, tunnel vision. It's a little scary to me. Those people that we don't.
Object to that being outside the record and an expression of the prosecutor's personal opinion, which is absolutely irrelevant to this jury.
Sustained, stay within the record.
Ask the judge, ask you to instruct the jury to disregard the last comments of counsel.
The jury will disregard the last argument.
The defense could have been making an objection like that at every one of these bells.
Yeah.
Throughout the course of their
And
entire
and
investigation.
And she just moves on. It never even happened, you know?
And that was
Like,
the
it
only
doesn't matter.
objection by the defense, by the way. The only one. And it got sustained. You think that would have encouraged them to object more?
And what did the Fort Worth Police Department determine? They talked to all of these witnesses. They looked at all of the evidence in this case. What you guys got over the last 2 weeks, that's what they had. Forensic interview from Zion, witness interviews. They talked to folks, the autopsy report, the photographs, the body camera video, frame by frame by frame.
So here she's basically arguing that because they decided to charge him, that means he's guilty.
Just like what we watched.
So burden.
They went through all of that and they determined it's murder. They issued an arrest warrant and a district judge signed saying this is murder.
And you know this isn't proper because the judge instructed the jury early on in the preliminary jury instructions when the trial first started that the fact that this defendant's in court, the fact that he's been arrested, is not a factor in determining his guilt.
Yeah. Not to mention the fairly obvious that the standard for an arrest or charge is quite a bit less than a conviction. So it doesn't mean the judge concluded murder at all. It doesn't mean that.
I mean, the threshold for getting charged is almost nothing.
Yeah.
For Ben, is it murder? The question that they raised this week was, is it self-defense? Is it self-defense? And what's really important about the court's charge is this is the law that applies. We do not view it based on what he says and only what he says. A person doesn't get to harm another, get up on the stand and say, well, I was doing it in fear of my life. And we just let them go. We just take their word for it. Imagine that scenario. Imagine what would happen if that were the law. Then not one single person would ever be held responsible and accountable for what they do if they can just say it is, so it is. That's not the way it works.
Anything like
the
what's
law
true.
is, and what you guys have in front of you.
What's that, Kurt?
Just saying that's not anything like true. That doesn't flow from the premise. It doesn't mean that no one ever would be held accountable under any circumstances. You're taking a specific and trying to make it into the general, which doesn't work. You can do it the other way around, the general into the specific, but you're trying to say, oh, this one thing is therefore all the things. No, that's not how that works logically.
Unless you convict this defendant, all criminals must be let go.
Yeah, that's not a thing.
Is that it has to be a reasonable belief and immediately necessary. And so how do we define what's reasonable, right? That's also in your court charge.
So here she goes wildly off the rails.
It's a belief that would be held by an ordinary and prudent person. All of you guys, with what he did out there, was that reasonable? Was that immediately necessary?
So they're not being specific to the use of force event. It's like what all he did out there. Was there anything that could have been unreasonable?
And here's one very important part. And I can tell you right now, when they get up and talk, they don't want you to focus on this. This is the law. This is what we're charged. This is what we're bound by. Unlawful deadly force. Unlawful force. The only way that this conduct is justified by this defendant is if it's reasonable to all of you what he did, immediately necessary. And the most important part is her, meaning Atatiana's, unlawful force towards him, or unlawful deadly force. The only way he is justified in his conduct is that it's to the degree the actor reasonably believes the deadly force is immediately necessary to protect the actor being the defendant, against the other person, Atatiana's use of unlawful deadly force. So think about that for a minute. What has been unlawful about what Atatiana did?
So this is the big misstatement of law in self-defense. It's not required that her use of force or threat of force was actually unlawful. The legal standard is, could he reasonably perceive it as being unlawful? It doesn't have to actually be unlawful. You don't have to make perfect decisions in self-defense. You have to make reasonable decisions in self-defense. And of course, this ought to have screwed him on self-defense. He should have been convicted of murder if the jury actually bought this, because probably Atatiana Jefferson's retrieval of her gun and pointing at the glass was not unlawful. If she had a reasonable belief that was a prowler outside her house with a flashlight at 2:30 a.m., if the jury believes that it could only be self-defense for this officer if she acted unlawfully, well, he should be done on self-defense because she probably didn't act unlawfully. But apparently they didn't buy that misstatement of law by the prosecution because they didn't convict him of murder, to the extent the jury was thinking rationally at all.
We have not seen one shred of evidence that anything that Atatiana did was unlawful. In fact, we heard quite the opposite. You can be in your own home, owning a weapon, owning a gun, and you can protect yourself in your home. That's one of the most fundamental rights. That's the reason we all feel so safe. Atatiana Jefferson didn't commit any criminal act by walking up to the window with her gun, thinking someone was outside. It's what many of us would do if we were in our house in the middle of the night in the back bedroom and we hear somebody outside. That's what you would expect us to do, to try to protect ourselves, and in this case, Zion as well. So there's not been any evidence to support anything that she did was unlawful. And you got to have that. That's what the law says. And if you think about it, it makes sense in this case because she was in her own home. If we can't feel safe there, where in the world are we going to feel safe? This defendant, when he put on this uniform, he has a tremendous amount of power, right? A tremendous amount of power. And when we talk about what's reasonable, when I talked earlier about the Fort Worth Police Department, when they went through and they did their thorough investigation of what happened out there, they considered all of what you guys have seen as well as the general orders. I put that in here too. You guys can ask for that. If you guys want to go through, you can ask for the general orders. You can see exactly what they say. It's not about what I say they say, or they say, or any kind of spin that the defendant wants to put on it when he took the stand. It's exactly what is written down. It's the very thing that the defense said in opening statement. They followed all the steps and procedures as you are supposed to. An open structure is a silent alarm, and he did everything right. That is what this Jay Coons got up here and said. He wouldn't agree with anything that we asked him, but that's the one thing he said. Everything he did was right. Well, that is not the case. Very first thing, officer receiving the call, that's him, right? He's the sheet officer. He's the main officer. He calls the shots. Step 2, B, all main exit ways should be guarded so as to prevent the escape of any defender. We start there and we fail, right? And that was one amongst the many, 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 many things that he did wrong, because it wasn't important to him to serve and protect that day. It was important for him to get there, get in the action.
Zero evidence of that.
Power. It can corrupt certain people. Certain people don't need to wear a badge. Certain people do not need to have the power and the control if they do not respect the accountability. And in this case, the grave effect that it had. Now, you guys have the ability today, over 3.5 years, we've waited. They've waited. They've waited for this day. Everybody in this room and all the rooms outside of this room and everybody in this community has waited for today. Because today, you say you can't create the danger and then claim self-defense. We want to feel safe in our own home. Today, you guys' decision in this case, finding him guilty, says, I'm holding you responsible. I'm holding you accountable. I'm following the law. And with the power you all have today, which is more power today to change lives, to hold people accountable than most people have in a lifetime. The power you guys have today is to hold him responsible. It's to tell them that it all wasn't in vain. It's to say that she matters. They matter. Eastside matters. We protect everyone. And the law agrees. Everything in this case, all of the evidence in this case, is demanding a guilty verdict. That is exactly what we are asking for from all of you today. We know what he does with power. What are you guys going to do with it?
Use it
Find
apparently.
him guilty.
Yeah. Convict him because you have the power to convict him.
Yeah.
Okay.
You have the power of life and death just like he did. So make sure to use it the same way as responsibly. Okay, yeah. That's good. Again, from a
Crazy.
rhetorical point of view, it's classic sort of rhetoric and public speaking that I've heard many times. It's well paced, not bad on the vocal variety. It's not overly emotional in sort of like being tired. She does a good job with the emotional regulation of the speech. So from a public speaking
That's the other prosecutor.
it's well-
The other prosecutor
Yes.
is the shouter.
Yeah. Well, they're both good then in their own way.
Yeah, I mean, I put the biggest responsibility on the defense. Arguing like, well, you can't create the risk and then claim self-defense. Well, you can, actually. It depends. I mean, even a homeowner, if you're on the second floor of your house, it's 2:30 a.m. and you hear stuff breaking downstairs, you can go downstairs and see what's going on, even though that's creating risk. You don't lose self-defense because of that. If you're a police officer responding to a call, sure, when you're investigating a scene at 2:30 a.m. for signs of forcible entry, are you creating risk? Of course. Is it an unjustified creation of risk? No, that's what your department trains you to do. You don't lose self-defense because you're following department policy. And they had not one witness who said he violated department policy, except that he didn't do 8 things simultaneously. So sometimes there are 8 things you should do, like guard this door, do this, do that, do the other thing. And you can't be in multiple places at the same time. So it's impossible. Unless every open structure call we're going to send 20 cops to, which in Fort Worth would apparently mean 20 cars because it's 1 cop per car. And then what's the criticism going to be for where they parked? Where are you going to park all the cars? It's crazy. All right. So here's a super chat, $10 from Scalzo Photo. He had previously said in a previous comment, he said, I'm tired of the incompetent cops. Did no investigation or surveillance, can't be held responsible for his horrific actions. And I had responded then, well, he was investigating. That's what he's doing. Then Scalzo says, and I missed this earlier, you ignored my point. If the officer had no idea what was going on, wait at the road, surveillance, talk to caller. That would be the neighbor who called. Don't shoot an innocent woman. Well, of course, with perfect 2020 hindsight, she's an innocent woman. You don't know that in the moment. He's not trained to stay out on the street and just watch the house. He's trained to investigate the call.
Yeah. What
and
information would he? What information
the neighbor had
could he
no
get
new
from the
information.
neighbor? Yeah. So
right. The neighbor had no
okay.
new information.
Yeah. So what? Talk to the neighbor to what end? Because the neighbor's going to say, "I've seen the door open. This is unusual." I mean, the doors have been open since. There's no point in it.
Right. But this is how people react. It's a very emotional and understandable human reaction. There's a bad outcome, so they're desperate. So, if something had been done differently, we wouldn't have this bad outcome. And that's true, I guess, maybe. But it doesn't make what happened, that alone, the bad outcome, doesn't make what happened a crime. Yeah. And you have to judge the defendant from what he knew at the time under the circumstances, not what we know later. Later, we know that she was just an aunt babysitting in the house. But that's not what the officer knew at the time. He didn't knowingly shoot a 20-year-old for babysitting her nephew. Let's see. Whoops.
Yeah, I mean, it's just like, okay, so he's going to talk to the neighbor who's not going to be able to provide any additional information. He's going to stand on the street, and presumably he's going to see a house with open doors with lights inside. Okay, and then what? Just stand on the what's next? Stand there indefinitely? I mean, I don't understand the flow.
He's got no other calls.
Situation. Yeah.
Right. Well, I got lights and sirens going by my office here. I don't know if that's coming over the microphone.
Don't talk to the police, Brenka. Don't talk to the police.
They're coming to get me.
Don't talk.
They're coming to get me. Well, at least they announced. Oh, yeah, the fire department's like 2 blocks from my office. I'm sure that's what it is. It's a fire call. All right, let's see. I saw somebody had asked earlier about the toxicology. So there was tox on the victim here. She was positive. I believe it was cannabinoids, marijuana. I don't think there were other drugs, but in any case, the toxicology report was excluded from evidence, so the jury never heard it. Let's see. Robert, Law Self-Defense member Robert asks, why would a good friend and neighbor in a safe neighborhood be afraid to knock on our door? His fear of knocking leads to police being put in danger. He said why he didn't knock on the door. He didn't want to get shot. He was afraid he would, either startle the owners of the home and get shot by them. And that happens, folks. That happens to cops when they rattle doors to check the doors. We had one here in Denver. Cop got shot through the door by the homeowner who thought it was somebody attempting to break into the home. Or if it was a burglary in progress, he didn't want to tangle with burglars. He said, I didn't knock on the door because I didn't have a gun. So he thought it would be dangerous to knock on the door. So that's why he didn't do it. That's why he called the police. So the police would incur that danger on his behalf, which is what we pay them to do. Law Self-Defense member Kyle says, Andrew's book is a godsend. I can't wait for Steve's book to get here. I'll be ready for my bar exam after that. Yeah, my book is awesome. You can get it for free, folks. Just pay the shipping and handling, lawofselfdefense.com/free book. And Steve Gosney's book is being extremely well received. I really, really enjoyed it. I wrote the foreword for it. Nick Queta wrote a little nice blurb on the back. You can see right there. It really is a wonderful book. A lot of insight, not just for lawyers, but for lay people as well, into how the law actually works. Steve's a very, very bright guy. You can get this book at crimelaw.net. Crimelaw.net. That's the only place you can get it, and I would encourage you to do that. It's quite a good book.
I have a copy. You should get one too.
It's yeah, I think everyone's got one at this point. All the cool kids have Steve Gosney's book. The funny thing was, when he first started coming on,
I have your book.
Oh, my book. Well, you should ask Steve for a book. I'm sure he'd get your book. Yeah. When Steve first started coming on, I'd say, Steve, you got anything to grift? And he didn't have anything. And I knew he'd written. He just for no compensation at all. He's just a geek, a law geek. He writes all these law review articles and articles for his office to read because he's involved in training the trial lawyers. I'm like, I know you have all these articles. You send them to me to read. I mean, why don't you just take them all and put them together and you got a book? It's like, hey, you think I should do that? It's like, yeah. And he did. He finally did it. I'm always telling people to do stuff like that, and they never do it. I think Steve Gosley might be the first one. Everybody doesn't, they don't want to do it. It's interesting. Admittedly, it's work. In Steve's case, he already pretty much had everything already written. Writing a book is actually a torturous exercise.
There you go. I just need to hire a ghostwriter to turn my videos into book form. It's got so much content out there. Go through my videos and turn it into a book.
We need a good AI,
civil law, the real
AI transcription.
Yeah, there you go.
So in years past, most of my blogs used to be almost entirely written. I'd write them out, and then I would use the written blog as a script, basically, to do a video version. And then, of course, strip out the audio, do a podcast of the same content. But writing is a lot of work. I mean, it takes hours to put together a good blog. And then I finally realized I could live stream. So now everything is just video and podcast. But some of my longer existing members, they prefer to read. I don't blame them. But we've been trying to find a reliable service that would transcribe the audio files. And it's remarkably difficult to get people who can do that on a reliable. What's that?
Yeah, the Open API just, I think, released, like just recently, they released a thing for transcription services, the artificial intelligence firm. So
yeah,
I think they have one that's might be better. OpenAI. I think they've got a transcription service for that might be suitable for your needs.
I mean, I pay for a transcription service, a commercial service that can do that. You upload MP3 files and they automatically transcribe it, and the accuracy is okay, so maybe 90%. But it's I have hours and hours and hours of recordings every week, and there's limits on the volume of stuff you can send them. At a reasonable price point. So that didn't really, and then someone has to review it and correct the 10% of it that's not transcribed correctly, because otherwise it gets really annoying to read. And it all comes as one giant fat paragraph. It's not broken up, structured in a way that facilitates easy reading. You really need a human for that. And I don't want to spend a couple hours a day doing that. And it's been hard to find a human being. We've tried some of these contract worker website services, but we've not been able to find anyone who could do it on a quick turnaround, reliable basis, which is too bad. I need some of these women who get paid less than men to work for me is what I need. All these gals who are so happy to work for less money.
85 cents on the dollar.
Yeah. That's the ticket. The things that gals will believe. Thank God, I guess. Let's see. So question, law self-defense member ALOL cat question, how does it work to not get these lesser included charges added so you can't get screwed by a compromised guilty verdict? The state says he committed intentional murder, or maybe he killed her by mistake. Seems pretty scummy. So normally the lesser includeds, if the state wants them, the state gets them, because the state's entitled to convict you on any crime for which they can prove the requisite elements beyond a reasonable doubt. And you can kind of imagine it almost like a cascade, right? So imagine murder has 5 elements, and manslaughter has 4 of those same elements, and aggravated assault has 3 of the 4 elements of manslaughter. Well, if they can't prove all 5 but only 4, that's proof of the 4 elements you need for the manslaughter. If they can't prove all 4 but they can prove 3 beyond a reasonable doubt, that's aggravated assault. The state's entitled to make those arguments. It's the cascade is there, and sometimes the cascade is really long. I mean, in the George Zimmerman trial, they charged him with second-degree malice murder, and there were a ton of lesser includeds. I think the jury instructions were 40, 45 pages, something like that. It was crazy. But speaking of Florida and the George Zimmerman trial, here's Mr. Florida himself, the author of Ideas and Answers in Law,
Yeah.
available exclusively at crimelaw.net.
Mr.
Hey, Steve.
Florida. I doubt that. I'm about as far away from that as it gets. That's funny. You are funny. Hey, how is everybody? Do we have a verdict? What's
No,
happening? Give me the
not
summary.
yet.
No?
Not yet. No, Kurt's been helping me keep the audience entertained, chatting back and forth. We played the state's opening. I played the Bell version of the state's closing again.
Oh, okay. Yeah. Well, I went through that with Ryan, and he thought it was. We actually have a few more additions because he's a really good trial attorney, and I'm a really good trial attorney. Hey, what can I say? But I'm in appeals now, and I've been in appeals for quite a while. But and it's always good to have a second opinion because we shot it off, and now it's getting out there. It's just what happens. You get a draft, and all of a sudden it's getting circulated. But I talked to Ryan about it. He did have a few places where he thinks we should have added some objections because what I did when I did it was we did the transcript and then put in a bank of objections for the previous paragraph, so to speak, right? Well, that's not necessarily reflective of where you should contemporaneously object to the statement. So we thought we would take a couple of those. It'll be basically duplicated, but they'll be brought up so it'll break up the paragraph a little bit. Because when the contemporaneous objection should come rather than subject matter. And of course, also the other thing that he added that I thought was important, and we probably need to do like a full hour and a half or two or something to go through this because we broke it out. And this was this was completely Bronca's idea, like all the good ideas. I'm just, and that was to take the seven reasons of 7 basic categories and put them in as an objection. But some of them are a little confusing because they are broad categories. And what they're doing specifically, for example, the burden shift one. And that one, it's when somebody's watching it, like a trained lawyer, like a Texas lawyer, like over here, if he's listening to it, it wouldn't necessarily come across as a traditional burden shift, which is burden shift traditionally is, the defense hasn't proven anything. Okay. But instead what it is it's a misstatement of the burden of proof. And usually what it comes is in this case is in the form of a straw man. So what they'll talk about is they will talk about how they're a good person and there's been no evidence of this particular thing and there's this evidence of good. Well, what they're doing is they're proving something that they don't have to prove. And by doing and something that there's no disagreement and no fight back from the defense. And because they are doing that, they are lowering their burden because they are basically telling the jury, our burden is to prove X, and that's been shown, and there's been no contest. Well, X was not an element of the crime, and X was not justifiable use of force that they have to disprove. So it's not something that they have to prove. So we state that, for example, as a burden shift, when it's actually under the general category of misstating the burden and recategorizing. So what we need to do probably is do a PowerPoint. Maybe we'll just do this as just for giggles and go through it one line by line, and we can explain why we're categorizing things the way we are. Because sometimes something comes across, it's one sentence and it's 3 or 4 things. And it depends how you categorize it, right? So you want to have that list. And I think this is a lot of my writing comes to as aides to our trial division. And, they miss this stuff too. So what I say is just have that article next to you because it's hard to catch these things on the fly. And when you hear something wrong, because what happens is it just bounces off your skull and it's like something's wrong here, right? But you're not sure quite what it is. Well, you've got 7 categories. So you just go through them. You say, okay, 1, it's a misstatement of law. 1, it's a burden shift. And you just go through it and you make those specific objections and arguments related to those objections and why it is that. And then you've preserved the record. So anyway.
So I think probably the easiest way to do that, Steve, would be for you, me, and Ryan just to do a dedicated show just on the closing.
Yeah,
just do a live stream show. And, you guys raise your finger every time you want me to pause and we can have a detailed explanation of what's going on, why we would object, how to think about this. And it'll probably take us a couple hours to get through 15 minutes of closing, but I think at the end, we'd have a great show and great content you could share with the trial division.
Yes. And actually, Ryan and I are working on a training because of this. I'm going to use this as a training tool for for our public defenders to identify bad closing arguments and to object, and then teach them how to walk through it. So yes, and then we could do a PowerPoint with the actual statements transcribed, and then the objections, and then the reasoning. So yeah, we're going to work on this, and Ryan and I have been already working on it, and it's going to be a great thing for our office as a training tool. And we can share it with the Law of Self-Defense American Law Courses community as sort of a bonus. A bonus.
Nice.
Yes.
All right. Well, just let me know how I can help if I can, and otherwise, I'm sure you guys will blast it.
Or we're working. We're inspired. You got to be careful when you inspire a public defender.
Let's see. See if I have any super chats going on. I guess I wonder if anything's changed about.
Oh, something else I did just while you're looking at that is I went over and just for giggles, I went over and looked at some of the source material for our trial stream. You know what I mean? And checked out the chat. And boy, the chat is completely bought in. I mean, they don't see, and I don't really, this is the thing, I don't really have a dog in the fight. I'm not for the cop and I'm not against the cop. It's a tragedy. And what the jury decides is what the jury decides, right? So I'm not real. I don't really have a chip on the roulette wheel, right? But what I do have a problem with is that the game is fixed itself. It's like playing roulette, and you're playing roulette, but you find the guy's got one of those little buzzers that they buzz, where they say that it's being cheating and it's not a fair game. Well, that's my problem. I don't have a problem playing the roulette wheel. I have a problem with the state cheating and having the game being fixed, and the rules are being broken of the game.
Yeah, it's terrible. It's and we just listened to the opening of the state again, as well as the closing with the buzzers, and the misstatements of law are just really egregious. It's interestingly enough, the most explicit misstatements of law are on the self-defense law. And yet the jury didn't buy that self-defense had been disproven, if we presume the jury's acting rationally, because they didn't convict him of murder. And he said, I intentionally shot her. So if it wasn't self-defense, then it was just straight up murder. It wasn't reckless. Right. I deliberately shot her.
Did you see the defense closings? Did Kurt see the defense closings?
We haven't done it again.
Yes, I did. I did see that. I saw it when it happened. I found the defense's closing like bizarrely technical. There was no passion or vinegar to it at all. It felt like they were trying to get away with something. Right. It felt like, well, if you consult section 2C 3DA4 fifth word, then they don't have that, and so as a result you have to quit. It felt like someone trying to get away with something when that is not really what should be the dominant feeling. Well, because I think it was just, and it was there was no really good arc to it. There was no real good, I liked both prosecutors in terms of their public speaking. I liked their rhetoric. I found it wasn't exceptional, but it was on a level that I've seen many times in sort of a competent public speaker. It's, there's good vocal variety, good pacing, good use of emotionality, not being overly emotional so you don't get emotionally drained. There was some passion to it. There were some good rhetorical points about feeling safe in your home, some nice things to sink onto. So it was a competent public speaker, which is fine. The defense, at least in their closing, was none of those things.
Yeah, well, you're measuring the emotional content, and Ryan and I had this conversation when we were watching it back and talking about it. Is that emotionally, the emotion was all on the side of the state. Mm-hmm. There was no theme from the defense that I could discern. It was kind of a scattershot, flat presentation. They didn't have a theme, and they bought into the state's misrepresentation of the law. But the passion, like you say, if I didn't know law and I didn't know closing arguments and I didn't know what was proper, I'd be like, yeah, if that's what I'm have to decide, then I'm all over it. I'm like, yeah, for justice for Tatiana, right? You know, let's parade around and I believe that she's innocent, and I'm going to an innocent person shouldn't be shot, and let's confirm that, and let's value the East Side, right? I mean, all of those rhetorical things, Mike, that's almost like what a television writer would write in Hollywood, and that these prosecutors said, "Oh, I wish I could do that." And then they go in the court and they say, "Now I have the power and I'm going to make these arguments." But it's completely divorced from what's right and what's wrong in the law. It's completely divorced what they should be doing. It's not, the content was absolutely vapid. And so that's, so you've made a good observation. That's why juries convict like this, right? Because they're listening to that emotional appeal, and that completely blows away any technical arguments, even if they're wrong. The emotion was all with the victim's family, and
it wasn't even really good technical. It wasn't even technical that was done well. I found even the technical aspect to not be well organized. It felt scattershot. It felt unmoored from anything. It felt like random dots in the dark.
Right.
It's like putting up a scattershot pattern and be like, what image do you see? And I see, it's a Rorschach test, and I see nothing. I see nothing, Steve, in this Rorschach. I see just dots scattered in the light. I'm sorry.
Teaching the trial division, we teach one of the number one things is, what is your theme? What's the theme of the defense? Well, we don't have a theme.
That's a problem.
That's a problem.
Right.
So,
there was no narrative here that anybody would care about.
Yeah.
I mean, and it could have been a lot of things. First of all, it could have been a lot of sympathy for Atatiana. They could have expressed that. There was very little of that. In fact, they tried to characterize her as a bad actor, right? She pointed a gun at a cop. That's the unlawful conduct that they got the jury to buy into as losing them self-defense. They could have spoken about, listen, we need cops, and cops have to engage in conduct that's complicated. It's risky. There's lots of decisions. Often there's no perfect choice. They're always compelled to make imperfect decisions, but we want police to respond to burglaries, right?
Yeah. Here's how I'm going to summarize it. I'm a patent lawyer by trade. It might be the most non-emotional field known to law. Okay. If you can't keep me engaged because there's not enough emotion in it, something has gone horribly, horribly wrong.
That's right. Boring the patent lawyer. That's
You're boring the patent lawyer. It's not going well.
Well,
yeah.
It's a problem. And but the gravest sin of all, really, and the one that really screwed him, is the fact that the defense read that law and saw that they thought that if the decedent here was acting lawfully, that you could not use justifiable justifiable use of deadly force. If you buy into that, it's over. It's over, because there was no evidence that she was acting unlawfully in any way. And so they were stretching, and they thought that was what the law said. And so then they're making up these things like, anytime you point a gun at a cop, it's a felony.
Yeah, that was a mistake.
Which is not, and if you buy into that dichotomy, if she's acting, it's over. She's guilty.
You can never point a gun at a cop ever. I'm like, well, you can if you don't know they're a cop. If you're mistake of fact gets you a long way in a lot of domains.
But not just that, but it doesn't matter what her lawfulness is. It matters what the perception of the guilty mind of the police officer, because we punish the guilty mind of the criminal. We don't punish them for making a mistake or having an accident, because there's no mens rea that goes to criminal intent. So therefore, if he thought that she was acting, she could have, if she thought that he was in danger of an unlawful shooting, then he was justified. If he didn't think that, then he wasn't. So there is a theory by which you could say maybe he's a racist cop, and he comes in there and he sees the black woman and he blang, 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 and he shoots her, right? I mean, there's a narrative there, but it's not. But that requires a culpable mind. Yeah. That's a guilty mind that we can punish criminally. But when the guy is making a mistake,
Andrew was mentioning this earlier, and I agree that the defense also made a mistake by not sufficiently showing why the cop couldn't have done the things the state did, because they're like, well, he made this decision and that was an error. Because, but the problem was, if he had did something else, it would have exposed somewhere else. Like there was basically there's no free lunch here, right? If they're criticizing him for like spending such little time like looking in the car and making only the most cursory look at the shed because he doesn't see any obvious signs of breaking and entering. And, so he doesn't investigate further. It's like, well, that was a mistake. I'm like, okay, but if he does that, okay, he spends more time looking at the car. He spends more time looking at the shed because, he wants to investigate deeper. Those decisions aren't free because time is a factor here, especially in the face of the unknown. You don't know what's going on in the house. It could be a burglar, and or it could be a hostage situation. It could be someone. The more time you spend rooting outside, the more time that you're making noise and shining your flashlights, and more time for them to finish up what they're doing and for you to be exposed. Like, these decisions are not free.
Yeah.
And it's like,
And
there's
the state was
there's no way to do everything.
Right. They should have spent more time on the garage with a flashlight, but using the flashlight was exposing their position. So it was both good and bad. And Steve was just funny. He was like, it wasn't like, he shot her because he was racist, blam, blam, blam. They actually criticized him for not shooting enough.
Oh, right.
Because he only fired one shot. That suggested that he didn't really think there was a threat. But if he fired multiple times, is there any doubt they would have criticized him for firing more than once?
Well, and this is part of the burden shift that we're talking about. And one of the things was they were talking about all the policies that he parked across the street. He did this, he didn't do that, and he didn't do that. And we showed you that he didn't obey, he didn't do anything right. Okay. Well, whether he did everything right or does everything wrong, see, that's persuasive testimony as to reasonableness of his actions. That's true. But to say that is the factor that you need to convict him on because he didn't obey the policy or didn't follow the policy, he didn't act perfectly on all these different things, therefore he's guilty. See, that's
where's the proximate cause, Steve? Where's the proximate cause?
Civil. See, this is civil, man. You're a civil lawyer.
It's also a criminal law concept. You got to have causality between the thing and the offense. There's got to be a connection between it.
Because he crossed the street across from the church, and he should have crossed the other way.
He didn't check the adjoining
murder. That doesn't really work for me.
I like when the prosecutor was arguing that he didn't check the adjoining buildings for sniper nests.
Oh.
He should have done that.
You got to do everything at once. Well, see, and it's kind of like when we talk here and people think we're taking a side with the cop or the defense or the prosecution, right? And the thing is that I can't say both things at once. So, if, for example, if you're in a murder case and you start saying, well, the defendant here, there's some mitigation. He had a tough childhood. He's had insanity or whatever. How can you say that when there's a dead, innocent woman here? Well, I can't say both of those things at the same time. So we usually lead off. You say it's a tragedy. What happened? There's a dead person here. The person's going to be punished. They're going to go away. Right. But on the other hand, there's some mitigation you need to consider. So you have multiple things going on at once, and you can't say everything at the same time. And it's the same thing they're applying to this cop is that, well, he didn't do everything at once. Therefore, whatever choice that he made was the wrong thing. It's really second guessing. In fact, we were thinking about this it's a half second mistake that results in a lifetime of second guessing.
Yeah.
How's that? I don't know.
And the defense
come up with a good theme.
Could have done a better job on all of that. The defense should have had that discussion with the jury. Look, of course he made decisions. Of course he can't be in multiple places at the same time. It's impossible to do everything. That's part of the complexity and the risk and danger of being a police officer. Nevertheless, we want our cops to go to burglary calls. We want them to make reasonable decisions, but no one can make perfect decisions because every decision is a trade-off. If this defendant had made different decisions, the state would be criticizing those instead.
Right.
They never explicitly made that argument to the jury.
Right.
So the jury's left with this notion that this guy, especially when they know their client was on cross for an hour and a half and 30 times conceded that he could have done things better, you better address that, or the jury will take that kind of amalgamation of small errors and mass it up into something that looks to them like recklessness.
Right. And the trial here and the subject is, did the state prove its elements beyond a reasonable doubt and disprove justifiable use of force beyond a reasonable doubt? Anything that is aside from those things is a lowering of the burden. Anything that's not talking about those things is not the point of this jury trial. And so when they're talking about all these side issues, they are not focused on the elements. And, and like they said,
right.
We were talking about if I was a prosecutor, how would I prosecute the case, right? That was a fun one. I've been working on this. See what you think. So the first thing is, there's no doubt that the defendant shot the killing shot, right? There's no doubt of that. So that's the identity is not an issue. We have a decedent. There's no issue that she was acting 100% lawfully. There's no accusation to anything, any other statement that she was acting nothing but lawfully, protecting her own home, investigating what she thought might have been a burglar, and she shot dead in her own home. There's no doubt on this, right? Okay, so then what do we have? Well, we have a cop who's coming up to his window with his flashlight, sneaking up in the dead of night and shooting a bullet through the home's window recklessly, without identifying the target, without understanding the situation, without understanding the complete situation. And this is a deviation from the standard of a reasonable officer who should be cautious and responsible for every shot that he fires. And in this case, he was acting recklessly and beyond the standard of what a reasonable person would in that situation.
Yeah.
Now, I'm not saying that I want to argue that. I would probably drop the case if I was the prosecutor. But I think that goes to the crime and his mental intent, which is recklessness, right? So I don't know. What do you think about my prosecutor hat?
Yeah, I mean, there's a lot.
I think it's probably the best argument that could be made.
Wife's home. I might have to head out. Hold on a second. I have to make tacos.
Tacos.
That's
can you
about
make me
all
a
I'm
taco?
qualified to make.
Taco Monday.
I don't know. That's just what it is. So I don't know. I'm just trying to do my best. Like if I was prosecuting, how would I prosecute this? You focus on the elements. Like how do you disprove reasonableness? You disprove justifiable force by saying that he acted unreasonably under the totality of the circumstances. And this evidence, and of course you'd want to bring up that the kid said that the gun was at her side. She's acting reasonably. He acted hastily and unreasonably. So you just have to kind of make those statements, and these facts make that statement. So that's where the
I'd be a lot more comfortable with the conviction if that was the argument the state had made. I mean, my counter argument would be, the recklessness has to be an unjustified creation of the risk. If he's looking at a muzzle, he's apparently about to get shot. That changes the circumstances. It's not like he had, all the time in the world to think about what was going to happen. The state here talked a lot about, he gave a command and then shot within half a second. Well, that urgency is compelled by the nature of the threat. The nature of the threat is a muzzle of a gun. So you're either going to defend yourself against it now or never. You're just going to take the bullet. I'm not sure taking the bullet, expecting the cop to take a bullet is a reasonable position to be in.
You're thinking defense lawyer. That's
right.
Yeah,
of course. Right.
And I'm with you.
I'm not saying that argument would win. Maybe the state argument would be more effective. The state could argue that, listen, the cop's the one sneaking around. The homeowner's lawfully in their home. If the cop's going to do that, he should be prepared to take the bullet. I could make that argument with a straight face.
Or that there's but focus on the time when he encounters that little split second, that 1 second period, when he makes the encounter and he takes the shot, that he is making that shot with the confidence that there's no other options. He could have ducked down. He could have run. He could have, escaped to a situation. And I understand that you've got some defense arguments about why he was trapped in that particular locale.
Sure.
But as a prosecutor, you could say he has innumerable options at that moment when he's confronting what he perceives as deadly force that he did not take. He chose the most deadly and the most aggressive method of attack, and that was to shoot his firearm at this innocent homeowner. See, I think that's how you build a state case there. And we would see when we're gaming these things, we talk about it like make your steel man argument. You don't make straw man arguments. You make steel man arguments.
Yeah, I mean, that's what critical thinking is, right? It's being able to put yourself on the opposite side of the argument. Let's see. For Steve, Law of Self-Defense member D says, for Steve, just received your book, sir. From your autograph, I presume your former occupation was medical doctor.
Yeah, no, it's horrible. Well, actually, Emily asked because we have to sign the certificates. So I had to send Emily some certificate. And I was like, I got to make this look good. But it's almost an impossible task. My signature is so bad.
I actually just initial everything. I don't try to sign out my whole name, even on certificates. But sometimes like I'll do one of my classes I do a couple times a year. We'll have 150 students. and I got to sign this giant stack of certificates. And you get to like initial 60 or 70, and suddenly your hand forgets how to write your own initials. It's like you start thinking about it like when you have to think how to tie a tie on someone else. It's like suddenly you don't know how to tie a tie, even though you do it every day normally.
Well, it's sad and humbling when you work on it several times and say, this is the best that I can possibly do, and it's pitifully terrible. It's like, ugh.
Let's see. From Law Self-Defense member LOL Cat asks, I asked this earlier, didn't know if it was answered, but do you think that the lead that passed was the storyteller? And without that, these guys, oh, I see, didn't have the chops to pivot to the defense mindset. So the lead counsel in this case died a couple weeks ago, died just the week before the trial started. Now, I guess he knew he was dying because he brought on co-counsel over the summer. So I guess he was in ill health. So it wasn't unexpected. And these guys were not brand new to the case. They'd been there for weeks or months involved in the case, but might that have inhibited their storytelling of the case? I think they had plenty of time, folks. I mean, it doesn't take that long.
Yeah,
the evidence is well established. The law is well established.
This was an easy case. This was an easy case. I mean, it was not complicated.
Yep.
This was not a complicated case. It was a very simple fact pattern, a very quick thing. It's on video. The evidence is known. The complication came with all the tactics of the state that were not countered properly. I think, like, for example, the defense did a great job. I don't understand this, but the one defense attorney did a great job crossing the expert of the state.
Right.
So they did something right. But see, like I was telling Ryan, the state brought in this psychiatrist to talk about his personality. How that's relevant, I've never heard of such a thing. I mean, and I'm very interested in personality types because I'm a strange one, as I think we have a collection here. And so I'm very interested in our strange personalities, but that has nothing to do with criminal culpability or aggravation. And then when one of the cross questions was, well, I see, Mr. Psychologist, that you are one of 4 and the other 3 people disagree with you. And he's like, yes, that's true. Well, where's the defense calling the other 3 psychiatrists?
Yeah.
Why didn't, your job is to advocate. Why didn't they call them? I don't get it.
Call each one, all 3 of them, one by one, up in the stand and explain why they disagreed with that first guy's assessment.
Right. I mean, maybe, I don't know what's going on. I'm just a humble commentator.
So super chat from Gets Dana, $5. Thank you. She says, I'll transcribe for you. I was talking about the difficulty I've been having getting a transcriber for much of my content. If you'd like to transcribe for pay, we pay pretty well, I think, for sitting at a computer and typing. If you'd like to transcribe, send an email to support@lawofselfdefense.com. Put attention Emily transcription in the subject line to make sure it's brought to her attention, and we'll be glad to chat with you about it. What I'd really love is have, frankly, this transcription work, it's not hard to do. I'd love to have 5 or 6 like stay-at-home moms who have an hour or 2 free a day, and we can kind of divvy up the work so it's not too burdensome on anybody, and everybody can make some extra Christmas money for their family, and that would be ideal from my perspective. Let's see, any questions? From Law of Self-Defense member Robert. Should the family sue the police force for not sending a SWAT team, a command center vehicle to the open structure call? Asked sarcastically. Yeah, I mean, there are practical realities here, folks. They can't send 20 officers to every open structure call. They only have 1 officer per car. They don't have an abundance of officers. They wanted 2 officers at the scene. They had to send 2 cars. If they got to send 20 officers, they're sending 20 cars. I mean, just think about the logistics. And it's not like there aren't other calls that have to be responded to in the jurisdiction. They have the number of cops allocated for typical police work, and they designed the procedures for typical police work. They can't send a SWAT team to every call prior to investigation that would give them any indication that that kind of backup was needed.
Yeah, I don't know. This kind of second guessing, but is dangerous. But it's the way it was done. It's the way it was done that's problematic. It's not the result, and I hope people understand that we're spectators here, right? And that the thing that bothers me is the way that it was presented, and not the outcome. Oh, because what did they decide? Kurt, I mean, you watched the closings just now, right?
Yep.
If you were on that jury, what would you think that you're supposed to decide?
Good question.
That something bad happened and somebody needs to be held accountable.
Yeah, that's about right.
And they had this whole mass of generalized, bad things like crossing the street, approaching the house, not slicing the pie, using the flashlight, using too little time on the garage. All these things they got the defendant to concede was not perfect police work on his cross-examination. And the defense did nothing to mitigate that, to take that away from the state as a weapon to beat their client with. And I expect he got convicted of reckless manslaughter, not because he was reckless in his use of force, but because the jury decided, oh, he said he did all these little things wrong. That must cumulatively amount to recklessness and therefore reckless manslaughter. If nothing else, you gave them an excuse to convict this guy of something when they know that's what the community is looking for. They're hearing the protesting outside the courtroom. I'm sure it's in the local press.
Yeah, this one feels a lot like a political trial, which I'm not really. That's not my bag. I mean, I try to comment on law, what's to be done. Although this trial has given me a really good teaching tool for our office and maybe for the country, so let's make some good out of something negative, right?
It's we'll see. I don't know. It's 5 o'clock there. It's 5:10, right? Your time, Kurt?
Yeah, it is 5:10.
And I have tacos to make. But
I'd imagine
what
the
is
court's
the
done for
plan?
the day.
What's that?
I was just saying, I imagine the court's done for the day, but maybe they're staying later. I don't know. Depends on the jury's
Yeah, I've got
probably.
the local media site up, and I have Law and Crime up, and they're not giving any indication. I mean, there's the normal people in the chat saying stuff like the jury's back and nonsense, but that's usually a scam.
I fell for that the first few times, by the way.
Jury
you don't know what a real
lies.
right. You don't know what real dickheads are until you look at the chat. Not all of you folks, but there's a handful of you in there every single time.
Yeah, there's so many good people in the chat, but there's the occasional mischief maker who really leverages that voice. And I think a lot of it's trolling, but you got to take it with a good humor because it's pretty funny, really. I mean, the fact that I fell for that, I was like, "Oh, Andrew, they said the jury's back." Hey.
Well, I know it feels like a long day to me, gentlemen. And anytime of course, I appreciate you staying as long as you have, and keep staying if you feel like it. You're more than welcome, but don't feel obliged if you got to get to tacos or anything else.
I
certainly
will take my
understand.
leave then.
Yeah, I think we probably ought to cut it down. I don't know. Do you judge announced? Oh, see there. I'm falling for it again. See, I'm so gullible. Judge announced a mistrial. That was good, Edmund. See, I fell for that. Initially I read it like, oh, okay. See there, I'm such a sucker.
That was mean.
That was good. I admire it. I admire good trolling. Yeah, you just have to laugh. I mean, it's really clever. I mean, there's a lot of wisdom. In fact, one of the things I like about this kind of forum and what we're doing with the closing arguments is that, I know there's going to be jokesters out there. There's going to be people making fun and picking on you. But there are people out there that really give you some serious commentary and some serious criticisms. Like they said, your volumes were off and, maybe you need to have a different, they're giving us some constructive criticism. You just got to sort through it, right? And there's a group think, like it's just like why we have different people chiming in on different angles, because we get in our little tunnel vision. I love working for the public defender's office because we bounce things off each other. And it's like, okay. And today, like Ryan and I were going back and forth on this thing saying, oh, what about this? What about this? And he's telling me, well, it's confusing what you're saying. And he can talk me out of a couple. I said, maybe we should delete that one. And then I talked him into some of my other ones. So, it was a good give and take. And nobody's perfect. We're all flawed. But by working together, we try to get the best out of each other rather than the worst. So that's some good management. And that's what you should try to do. When you're working with somebody, try to get the best out of them, not the worst. So anyway, good call, Edmund, on the mistrial call for the judge.
Yeah, in terms of if there is a mistrial, apparently what happens is they would mistrial just the punishment phase and dismiss this jury and impanel a different jury to try the punishment phase again, which is weird to me because that new jury didn't see any of the trial. So
I don't understand this. This is the thing. I'm really out of my element when it comes to jury penalty phases, except for death penalties, which is a whole different bag. And death penalty, there's a whole, but it's hard to apply that. I don't have any clue what Texas does. Did you, and civil, by the way, we had a drink. He just passed the Texas bar and is now a Texas lawyer. Congratulations. We had a drink on his event. But on that head, was there a part on the bar exam about this penalty phase in the trials?
No, Texas uses the uniform bar exam, so it is uniform. There was a Texas law supplement that I had to do for 12 hours afterwards, but I don't remember that coming up during the supplement. I did learn a little bit about pooling obligations for oil and land rights, though. So if you want to talk about that.
Yeah, right. The neat thing about civil law is very. I
also learned that the Fourth Amendment applies to private actors in Texas.
See there, you learn it all the time.
That's interesting.
There you go. Yeah.
Civil law is interesting legally. The facts are very diffuse, and the law is very complex. So but by the time, the stories that come out of it are hard because it's like, well. And then I filed my 8th amended motion for dismissal, and it was partially granted on and it's by the time you get done explaining it, people are like, what are you talking about? Whereas criminal law is like, the guy got hit in the head with a bat, his brains splatter all over. Wow, that's cool. So the stories are better, but the law usually the law is a lot clearer, a lot more certain, and things are a lot more railroaded. Whereas civil or uncivil, I don't know, civil, uncivil. It's civil law is a lot more complex,
a lot more ambiguous,
subject to different evidentiary things and dirty too. It's funny that people think that like criminal law is dirty. Jeez.
Oh yeah, no man. Civil law attorneys get real mean. They get
vicious because their money, because they're getting paid by the hour and by their result for their client. And that's the only thing that matters. So you're in the way of their breadwinning for their little baby lawyer mouths. And so you get vicious lawyers. We're in the prosecutor, you'd think it'd be the other way because we're talking about somebody's life. But generally, criminal law is a little bit more civil between attorneys.
That is the general consensus.
I did civil law for 6 years and it drove me out of it. I didn't like that part of it at all. It was very miserable.
I think I'm going to join Steve down there in Florida and become an appellate specialist, though, because that sounds like fun.
Yeah. Well, we have lots of room. I don't know what we're doing, and it's appellate.
Do you mind someone whose style is a bit snarky and slightly irreverent? Does that work for you?
Oh, that's required.
Okay, great.
That's right.
I saw a question come by.
A job qualification.
I saw a question for you, Steve, and I can't find it now, so I'll have to recall it from memory. But they were asking about your book. Is there a part in the book that covers trial prep?
Oh, that's a good question. And we've talked about this, haven't we, Andrew? Because I teach a class. See, it's tough because how do you craft a class or a book on how to do a jury trial, from the defense side, or basically trial prep and trial practice and trial advocacy for criminal trial lawyers? That doesn't have a lot of broad-based appeal. I teach that. In fact, I have a class coming up, I think in January, with some of our misdemeanor attorneys where I'm going to be teaching them. It's a full day class. Sometimes it runs into 2 days where I give, and it's approved for CLE, and I teach them how to do trial practice. And also I do a similar thing for appeals. But how, and the answer is no, it's not in the book. It is. Well, let me take a step back. In the closing argument portion, in the closing argument chapter, the first part of that is how an ethical and proper closing argument should be done by a prosecutor. So it's not enough that you criticize. you have to offer constructive solutions, right? And so I used to train the prosecutors in a prosecutor's office, and that portion of the chapter came from that thing. Here's how to do it right. Here's how to do it ethically. Focus on the issue, follow the law, and it's a blueprint. It's a step by step. It's almost a paint by numbers. It's very easy to do it right. But then it gets into all the ways you can do it wrong. But we've been talking about how to do a class, or who would be the audience, who would buy this class on how to do a defense work. And I don't know. I'll leave it to you to imagine that, because I don't know. I mean, I train the people in our office and they love it, but.
Yeah. So I've got a question here. It looks like it's for me, from Law Self-Defense member Paul in Florida. He asked, do you think it's ill-advised to belong to two carry insurance plans? So two self-defense insurance plans, like I guess CCW Safe and Law Shield, or Law Shield and USCCA. Well, for me, the most straightforward answer is there's only one of those plans I like, and that's CCW Safe. So that's the one I belong to. I wouldn't bother being a member of any others. The risk, of course, with having multiple carriers, and I think it's USCCA actually added language to its members' membership terms about this. If you have a second company covering that they want, you have to tell them who that is so they can kind of negotiate a split of the coverage. To me, it just seems like it makes things more complicated than they need to be.
Then they have subrogation claims where the insurance companies are suing each other about who has coverage, and you're fighting that battle.
I just don't think it's worth it. And I don't see what additional value you get out of, say, if you follow my recommendation, it would be to become a member at CCW Safe. In fact, you can save 10% off your membership there, the annual membership. If you point your browser to lawofselfdefense.com/CCW Safe, you can save 10% off your membership there. Use the discount code. I don't remember the discount code.
Well, the
LSD10. I think it's LSD10. And by the way, if you are an elite member, or whatever they call their highest level of membership at CCW Safe, you can also be a platinum member for half the normal price.
Ooh.
So something even less than half. I think it's a third of the normal price.
Yeah, and I can think.
How do you do that if you were so inclined to do that?
You'll have to ask the CCW customer support people. They have a mechanism for doing that. And I'm not sure how much they promote it onto their own members, to tell you the truth, but we set that up about a year or so ago.
Nice.
So say that deal again. It's so if they're a CCW member.
Right. So you pay whatever their membership is for CCW Safe to be an elite member, or whatever they call their highest level of membership. And you pay them, and then if you're one of those members, you can be a Law Self-Defense Platinum member for 1/3 the normal Platinum member cost.
That's a good deal. Well, I can think of a couple reasons why you would not want to do that. One is that you have this subrogation claim issue, and if you need your criminal defense insurance immediately, then you'd want it immediately, and you don't want to be fighting. You don't want to have your insurance companies fighting each other about who pays for it, or be involved and have that to deal with anything. Second, save your money. I mean, if you've got the coverage, you got the coverage, right?
It's not inexpensive, these plans. I think they average about $50 a month for their higher level plans. So that's $100 a month. I mean, I don't know, adds up.
Hey, I got to go. Nice seeing you, and we'll be in touch.
All right, I'm going to plan, assuming that a verdict doesn't come in shortly, I'm going to plan to do the same thing tomorrow. So I'll send out invitations to everybody, and whoever can make it based on interest and availability, feel free to pop in and out as it suits you.
I guess I'll sign off as well. I'll see you later.
All right, Kurt. Thanks for coming in. Thanks for spending so much time.
No problem. Bye-bye.
All right, folks. Well, there's not much new going on. The discount code for let me see if I can find it. Bum. Let's see. LSD 10. So if you go to lawofselfdefense.com/CCW safe, that'll redirect you to the appropriate page in their site. And you use the discount code LSD10. You can save 10% off your CCW safe membership. And then after you get that benefit, contact their customer support and you'll be talk to them about the option to become a Law Self Defense Platinum member. I believe it's half off the Platinum membership if you're not the highest level CCW safe member, and it's 2/3 off the Platinum membership if you're the highest level CCW safe member. But they can tell you about that there. Yeah, I really like CCW safe because they do more than just cover your legal expenses. They actually land their own investigative team, highly experienced, retired but highly experienced homicide detectives who are investigating the scene, talking to witnesses, talking to the police on your behalf.
Hey,
Danny.
going.
So far so slow, I guess. No news yet.
Oh. Well, I'm disappointed.
Yeah.
I ran home from work doing a job I don't really even care to. Who gives you assignments on your last 2 weeks after you've already resigned?
Yeah. I guess
Silly
they're mad.
Sorry, are you live right now? I just hopped
Yeah.
right on as soon as I got back. I'm sorry.
No, we're live.
Sorry to the audience. I don't know what you were discussing before I hopped on. So,
well, Kurt and Steve Gosney popped back on. They just signed off just a moment ago, less than a minute ago, I think. And we started talking about CCW insurance, self-defense insurance. My recommendation is CCW Safe. Go to lawofselfdefense.com/CCW Safe. Use discount code LSD10 and save 10% off your CCW Safe membership. And if you're the highest level CCW Safe membership, you get my Platinum membership at 1/3 the normal cost. And if you're any other level of CCW Safe membership, you get my Platinum membership at half the normal cost. So it's a pretty good package deal, folks. And I was saying, I really like, good deal. I like working with those CCW Safe guys because they do more than just pay your legal expenses. They actually land, they fly in to the scene, their own investigative team, highly experienced retired homicide detectives who are effectively your detectives. They're talking to witnesses. They're looking for evidence. They're talking to the police. Because if you don't have that, folks, the only detectives investigating work for the state. They work for the prosecutor's office, effectively. And they may not be as attentive to exculpatory evidence as your own investigators would be. And that can make a huge difference. That evidence, and often the evidence has to be collected in a timely fashion or it goes away. Witnesses disappear, physical evidence disappears. So the fact that they fly in a team, put them on planes to land at the scene to be your detectives is a game changer.
No, it's
any
a great
other
program.
company that does that.
It's a great program, especially if you live in a jurisdiction that it's applicable to, and you live in a dangerous neighborhood. I would sign up for it.
It's yeah, I really like those guys. Unfortunately, there's a couple states that don't allow for self-defense insurance. I think New York, maybe Washington. You'll have to ask them about that, but most states you can get it, and I think they do a fantastic job over there. Big fan. I do a lot of work with them. Full disclosure, I do a lot of partnering with them. Most of the other self-defense insurance companies I just cannot recommend at all, so I don't. Lesson here. Someone comments, never be a cop. It's a difficult time to be a police officer these days, that's for sure.
Yeah.
And yeah, someone mentioned earlier in the chat that they have a buddy who works for the Fort Worth Police Department, and they say, as of right now, if there's an open structures call, they don't respond unless there's gunplay happening.
Are you serious?
Yep.
Oh
They'll
my
get there
gosh.
eventually, but nothing's going to happen in a timely manner.
That's why I carry all the time. And if I were to live in Texas, I would carry all the time. But that's a shame. That's really a shame.
That's a shame. Super chat, $5. Thank you. This was the question to Steve that I couldn't find. Does your book include tips on organizing for trial? I don't believe his book does. But now that you've planted the seed, I expect he may pull something together. So next time he's on, I would ask him about that.
He does propose a lot of solutions, and in terms of like legal strategy that is actually really helpful in preparing for trial. But that is a good idea for him to build on.
Law self-defense member Kyle says, "Hi, Danny. Andrew is very knowledgeable about the law of self-defense, but you're easier on the eyes."
Oh, thank you.
Yeah, pretty privilege. It pays.
It does. It's a blessing and a curse. Let me tell you. Let me tell you, as an attorney, it's very, very difficult. I have had judges call me all kinds of things. I've had opposing counsel get away with calling me things that they would never, ever try and do if I weren't wearing makeup. I'll tell you what. But it's fine. I move on. You live with what you got.
Let's see. Can I put the CCW safe link in the description? I'm having trouble finding it. I think so. Let's see. I don't know. Can I add it to the description midstream? Let me just make sure it works first. Yeah, it works. So I'll put it in the chat right now. I'll put it in the member chat too. In fact, I'll do it again this time with the correct discount code. LSD10. They say it used to be LOSD10 and they changed it on me.
I'm actually going to turn on
I think it only works. Let's see.
Sorry.
That's okay.
Video production correction there.
Yeah, that was one of the hardest things for me when I started doing this, was getting the lights and the audio correct. It took forever.
The audio is a nightmare. I hope that this microphone sounds better than what I had before.
It sounds fine. What did you get?
So I got this super cheap Fifine type microphone. It came with the set for my like arm setup, which I really needed. But I am really disappointed in this Blue Yeti. I wouldn't be disappointed if I had like a studio with sound blockers and everything.
No, they're terrible.
Else. I think this would be perfect. But as it is, it's too echoey and it picks up everything in the room and you just don't hear me as clearly. So.
Yeah, no, they're not. The Yeti's only good if you have like a bunch of people around the table. It's almost like a phone conference calling microphone because it picks up everything in the room. I used to have it pick up birds chirping outside of my window. You could hear them in the podcast. It was crazy. No. But this, I mean, this is the SM7B, which is a very nice microphone, but it's pretty pricey. But it's wonderful because it mostly only picks up sound within a couple of inches. Unless the train is tooting its horn going by. And Shure also makes a smaller microphone now. I don't remember the number, but it's a USB microphone. I use it as my travel mic, and it works really well. I would recommend that one too. In fact, if that one had been out when I bought this one, I probably would have bought the other one. But now I can't. Shure, smaller microphone.
So I think that this delay, and I'm sure you've already discussed it with all your guests, and I'm sure I'm not the first person to say this, but I think this delay is indicative of a jury that has no clue what they're doing. And they're kind of making it up as they go along, and they're terrified of political ramifications. God forbid someone finds out that they were on the jury, right? I really do think that. I think that the sentencing generally, when they came to their decision, it was pretty clear that they were just trying to shoot somewhere in the middle, forgive the pun. But they were trying to aim for something that wasn't quite murder, but also wouldn't appear as though they were just letting this guy off.
Yeah, it's interesting. And because the sentencing is by jury, there's this weird quirk. So what just happened? Did I lose? No, I'm still live in Long Crime. What happens if the jury can't unanimously agree on a sentence? right? Because normally we don't have to worry about this because the judge is deciding the sentence and he's going to agree with himself, of course. But we have 12 jurors. What if they can't agree on a sentence? Well, then apparently it's a mistrial for the sentencing jury, and they would dismiss this jury and panel another jury and have the new jury consider sentencing. But of course, that new jury didn't watch any of the trial. So all they would know is whatever, witnesses are presented during the sentencing phase. Like we saw here, there was a couple of witnesses, family came up, that kind of stuff. That weird psychiatrist came up to testify for the state. I guess they'd hear that evidence again, but they wouldn't hear any of this substantive evidence from the trial. They wouldn't have heard the defendant testify, for example, which is pretty important. They wouldn't have heard any of the experts testify. They just hear the little mini testimony of those handful of sentencing witnesses and be expected to come to a verdict.
I'm going to say this and it's crude, but there you have it. This is ass backwards. That's what that is. Because if it were like, if you have a sentencing judge, right, it's still the same judge that witnessed and
Right.
saw all of the evidence and understands the law and is basing his sentence or her sentence on, the facts and the evidence that were presented at trial. And when you're looking at an appeals court and what is important to the appeals court, that's what the appeals court wants to know is, did the judge make a good decision based on the evidence that was presented at trial that was admissible? I would think that when it comes to appeals in Texas, it must get very messy when the jury does this, when essentially you have to have a full new trial just to get to the sentencing portion.
It's crazy. A lot of weird practice stuff in this text. All these running objections and lack of objections by the defense where that really seem inexcusable, but I wonder if it's a local practice thing, but it leaves a hot mess for appeal. It seems like nothing's preserved for appeal. And
that's where I'm like, their appeals court rules must be very different. Their procedural, substantive process must be very different than other jurisdictions. That's all I can think, because how else would you manage all of this kind of madness, frankly? I don't know. Maybe the Wild West lives on through Texas law. But
well, it looks like court might be done for the day.
really? Oh, it's 5:35 their time.
See you back here tomorrow. It says WFAA, the local channel I'm streaming. So I guess that's it, folks. Which is good. I'm tired. I've been here a long time.
I bet you are.
So Danny, why don't you tell people where they can find you?
Please come and check out my channel at Danny on Direct. I will be having a podcast. I'll be having a live stream tonight at 8:30. We'll be discussing the TikTok ban here in Utah, as well as the Twitter files addendum. And I'll be having a moment of a little bit of house cleaning stuff to get through initially, but hang tight. It should be a lot of fun. Come and check out my other videos where I interviewed the DUI guy and Steve Gosney. He's phenomenal, obviously, but you get to get a little more insight into their background, their career development, where they came from, why they're here today, and how you could maybe potentially end up in their shoes one day and be successful and brilliant attorneys. And I need to get you on. You're always invited, of course. I always send you links, and I do. I invite all other attorneys to join my stream because I recognize that we all have different things to bring to the table, and it's fun. It's a lot of fun.
And you had a celebration the other night, right? What was it? How many subscribers?
3,000 subscribers. 3,000 subscribers, and I just got like another 100 today, so 3,100.
That is awesome. Well, if it's any encouragement, I only do this YouTube stuff in a very occasional, half-ass kind of way. I'm not really a law trooper. To me, it's whenever the opportunity comes up. So I don't put out content with the frequency that you really need to be successful on this platform. And I just broke 46,000 subscribers somehow. So I don't even know how that happens. But if you're more diligent than me, you could expect better results. So I'm sure you'll grow your subscriber base very, very quickly.
Yeah, I'm trying to be diligent, but it's tough because, and I'm sure you've experienced this, a lot of this stuff is outside of my depth of knowledge. And so I'm trying to broaden my understanding of certain areas of law, which requires a little bit more preparation in the videos. And so I'm just trying to ease my way into it and feel it out, find my rhythm, and hopefully I'll be uploading a video once per week. And then if I can live stream almost every night, then I think we're going to be in good business. So.
Well, I'm going to plan to do the same thing tomorrow that I did today, live stream from the morning. Presuming court starts 9 a.m. Central Time, so 10 a.m. Eastern Time, 8 a.m. Denver time, Mountain Time. And I'll send out guest invites to the usual crew, and whoever can pop in and out as their schedule and interest allows is more than welcome. And hopefully we won't go through another entire day with nothing happening. But I guess we'll see. So, all right, Danny, I'll say goodbye for now, and look for my invite in the morning.
Will do. Oh, and before I leave, I posted our video, the 6 hour, on my Facebook, and there's a lot of people on my Facebook who follow me from my campaign, and many, many people said that they have either worked with you, read your book, or have been following you for a long time and are big fans. So
that's a polite way. That's a very polite way of saying I'm old.
No. What I mean to say is you have a really strong fan base here in Utah. So when you come out here, we'll party it up and have a good time.
Yeah, I can't wait. I need to get out I got to do more motorcycle riding in Utah. I just hit like the southern edge, like Bryce Canyon and Arches and Canyonland, but I've never gone deeper into the state. So one of these days I need to get up there. You're in the Salt Lake City area?
Yeah, I'm in Salt Lake County, but it's 4 hours from anything. So you might as well just call me when you're near the border, and I'll meet you wherever you are. So, and I'll show you all my secret places. There's so many cool places to visit here in Utah that most people have no idea exist. And then when they see the pictures, they always go, "Oh, well, where is that?" And I'll take you there. It's a lot of fun. So,
all right. Sounds
love.
Awesome. Thanks.
Talk
okay, take care, Danny. All right, folks. I'll just clean up the last few super chat questions, and they're both from David. David, $5 super chat, says, I live in Maryland and I have a handgun permit. And since the Supreme Court ruling, I can get my CCW, the Bruin Supreme Court decision. I hope to never need it, but you never know. I have a CCW. I don't think we should have to have a CCW to carry concealed for lawful purposes, but I'm glad in Maryland you can get your concealed carry now. Another super chat from David. He says, Maryland law is one of the worst states for self-defense. Thank you for what you do, helping out us plebes in case the worst case scenario plays out. Yes, Maryland is one of the 11 states that is still a stand your ground, a duty to retreat state. And Maryland's pretty aggressive. All the duty to retreat states are pretty aggressive about enforcing that duty to retreat provision, unfortunately. And let me take a look at the member area. Kyle, Law Self-Defense member Kyle says, subscribe to Danny. Looking forward to it. Yes, Danny on AHN Direct is her YouTube channel. Folks, even if you just played like some of her videos in the background someplace while you're having dinner or doing something else, it's important to her that she builds up her number of hours viewed on her channel. That's one of the criteria YouTube uses to determine if you can monetize your account, do things like super chats, have advertising, all that kind of stuff, make the YouTube a revenue generating experience for the content creator. So the sooner we can get her over that threshold, the better. And a big thing you can do to help is 1, subscribe. That's a key factor. And 2, viewer hours. So, if you got a laptop around the house you're not using, pull her channel up, start some of her streams and just go off and do something. She'll still get credit for that in terms of viewer hours. All right, folks, I think that's it for today then. Again, 10 a.m. Eastern, 9 a.m. Central, 8 a.m. Mountain, 7 a.m. California time, Pacific time. I'll plan to start another live stream, follow the trial proceedings, have guests come in and out as opportunity presents itself, maybe replay more of the trial. We didn't actually get to too much of that today because we had so many good guests come in, and we'll see how things go, and hopefully we'll get a verdict. Until then, I remind all of you that if you carry a gun, so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to make sure you know the law, so you're hard to convict. Until tomorrow, I remain Attorney Andrew Branca at Law Self-Defense. Stay safe.